side. Ken Chaudhary, I seek adjournment in item number 5, my lord.
5.
Yes. Looking after 2 weeks, my lord.
4, 5.
Ranjit Sharma, right?
Hmm?
Ranjit Chan. 5.
Ranjit to 5,582.
মানে উঠে আছে
এইটো
নাই, নাই।
ফোনটো আপোনাৰ কিমান নম্বৰ?
Ranjit Sharma.
কেই নম্বৰ?
Item কি মানে? Question?
নাই।
Oh, no, sorry, my
Nine.
9.
এইটো
very
Nine,
different.
9. Sorry, my lord. Item 9.
Yes.
Let me come after 2 weeks.
Okay. On the prayer of Mr. Arpichar, learned senior counsel for the petitioner, let this matter be listed after 2 weeks.
Authorized.
May it please your lordships, I have also similar pair, my lord. Item number 10 and 16.
Then KDB, huh? 16, huh?
Highly obliged.
May I please, I make a mention regarding withdrawal, your lordship,
The matter has been
some infractions.
Hmm.
We come up to work tomorrow.
Withdrawal.
Withdrawal. What's matter, your lordship? Obliged.
Please, the lordship. Lordship, I am apology for lordship. Item number 2, my lord.
Hmm.
My lord, respondent file affidavit, my lord.
Hmm.
We have to file reply, my lord.
2018 matter.
My lord.
Why?
My lord, that man, I am communicating by, there is no phone number and I am communicating by letter also. She is not. my
On the
lord.
prayer of Mr. N. Bora,
Please,
no,
last
Mr.
sentence.
N. Bora, learned counsel for the petitioner. Press for and is granted 2 weeks time
My lord.
to file affidavit in reply. Mr. It is made clear that the adjournment of the matter is allowed, adjournment is allowed only as a last chance as the
Right,
matter is
right.
pending since 2018.
My lord.
May it be pleases your lordship?
Yes.
Your lordship, I beg to mention items 6 to 8, your lordship. Concern has made, your lordship, taken from BP Bora, your lordship. The affidavit has sent for vetting, your lordship. Kindly.
Okay,
list
it
this
is
matter
submitted
after
by
2 weeks.
MS.
Piras.
P. Das Learned Standing Council Secondary Education. That affidavit, affidavit has been sent for betting. Therefore, praise for listing of the matter after 2 weeks, 3 weeks, 2 weeks. Huh? Praise the Lord, list after 2 weeks.
Deeply obliged.
In the meantime, the state standing council, Learned Standing Council filed the affidavit.
But with the concern of the other side, my lord, I beg to mention item 22, 23 and 24.
22, 23. Yes.
Here, my lord, Mr. D. Upamana is some health issues, my lord, today. And moreover, instruction has not been received, my lord. So it's for the 2 weeks. time.
We'll say on the prayer of Mr. As does Learned Standing Council Higher Education. That this and as consented by the Learned Council for the petitioner. Have you taken consent?
Lordship, I put a petition.
Let this matter be listed after 3 weeks so as to enable the state to file their counter affidavit.
Lordship, may I
Mr.
humbly be Katonian.
P. Kathaniar, Learned Council, but the petitioner is present.
So may I humbly pray for a date, any date after 3 weeks, Lordship.
3 weeks. Give the date.
10 June. Obliged.
Number 29, my lord. I have
29.
Lord, I am
yes.
the respondent, my lord. I
Hmm.
required some time to file my affidavit, my lord. I have taken the consent from the other
Bonus,
side. my lord.
bonus.
2 times I am appeared on behalf of petitioner. 2 times already taken, my lord. So, my lord, a short date may be given, my lord.
2025 matter.
But I am no longer in service, my lord.
You are seeking the 2018 matter for 2
No,
weeks.
that is another one. I
Then
am-
2025 matter you are seeking in short.
No, 2.
Yes,
2 weeks.
Mr.
AB there, my lord.
AB de Learned Counsel for the petitioner. The Learned Counsel for respond number 2. 2 to 5. prays that matter may be, prays that he may be granted 2 weeks time, 3 weeks.
2 weeks, my lord.
2 weeks time to file affidavit in reply. List of prayer not being objected to by Mr. N. Boralan, counsel for the prayer. Let this matter be listed after 2 weeks for filing affidavit by the respondents. So as to enable the respondents to file their affidavit.
Marks will.
Prayer in item number 32, my lord.
Hmm.
For the petitioner in this case, AB there, my lord.
Huh?
Taken consent from the state, my lord. I have a personal difficulty today, my lord. Can it be listed up to
Mr. Abi, the learned counsel for the petition has submitted he has some personal difficulty today. Therefore, first for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks. 2 weeks.
May I please, your lordship, with the consent of the other side, I beg to mention item number 13,
1-3.
1-3.
Yes.
My senior legal aid counsel is
You are for
petitioner.
Mr. Islam. Are you Islam?
I am A.S. Mullah on behalf of RSP.
Learned counsel for the petition submits that Mr. Islam, legal aid counsel has some personal difficulty today. Therefore, first for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks.
My lord, this matter may kindly be listed tomorrow.
Why?
Constitution of SMDC,
Huh?
it had to be constituted after
Monday.
calling a public meeting.
This is what? New better.
It is matter of 25, but not listed, that is why, my lord.
Monday.
May I please, Lordship?
Hmm.
I beg to mention 2 WPC matter in admission column. Lordship.
After
it is
what week?
Listed on 27th March
After 1
2026.
week, yes.
Finally, list the matter.
27
27 March,
March.
March 2026, last listed.
Ah,
Kindly list the matter on next week, 21 May.
after a week. After a week.
Right, Mr. Lordship. With the consent from the other party, I beg to mention item 12, Lord.
Item?
12.1.2, Lordship.
Ah,
Lordship may kindly adjourn the matter to
you are
the
for?
H. Chakrabarti for the petitioner, Lordship.
MS so and so learned counsel appearing on behalf of
Lordship,
Mr.
there is
H.
interest-
H. of Property learned counsel for the petition. Press that term may be listed. Press submits that Mr. H. Chakraborty has some personal difficulty today. Therefore, first for listing of the matter after 2 weeks. Praise the Lord, list after 2 weeks. Interim order passed earlier shall continue.
Yes, Lordship.
This matter is similar to that from the series matter taken up by Lordship on 11 May.
Ah. This is disposed of.
Proper portal. Here also, Lordship, this school was private institution and run without permission from the authority.
What is the order, dear? Okay.
And similar order, Lordship.
Yes, Mr. R.C. Alam. Same
M. Raman.
order.
M. Raman, lordship. M. Raman.
Your name is there.
Yes.
Same order. Your R.C. Alam. 2098. Same. Huh? Same. This is what same access to the phone in terms of notification and same. 10-5. This order is same.
Same, Lordship. It was also for without permission.
No, this order is 9-5.
Yes, 9-5.
Only order will be different, huh? 9-5. Earlier one is 10-5. This is 1-5, 9-5. Same contents. 10 or 9. This order? Verbatim.
Lordship.
Same. Verbatim. Except the name of the school. Same order. Heard, Mr.
M. Raman.
M. Rahman, learned counsel for the
Without permission, আছে?
petitioner. Then you write this, same order, same order. Dispose of, huh?
দি দিম, হা? বাবন,
Dikher.
বাবন করে দিম।
Same, it's here.
Because this order no state item one.
You don't want to take steps.
We had taken steps, your lordship, but due to some inadvertent error, it had come in the defective section, your lordship.
It is submitted by Mr.
A Mishra, lordship.
A. Mr. Learned counsel for the petitioner that although steps have been taken, due to technical defect, it is pending in what?
In the filing section, your lordship.
In the filing section. He undertakes to cure the defect and take steps accordingly. Considering above, let this matter be listed after 4 weeks,
1 week.
4 weeks. In the meantime,
Lordship, 2 weeks. 4 weeks.
3 weeks. In the meantime, the then counsel for petitioners to take the necessary steps.
Petition item 3.
Wait, please, your lordship.
Yes.
Lordship, we had received affidavit in opposition filed by the respondent number, my lord, 5. My lord, in that, through that affidavit, this case has no merit, my lord. Your lordship may dispose it of.
Saying what?
My lord, because we have silenced her certificate, my lord, but she has.
It appears to be
Yes, my lord.
correct.
Yes.
So withdraw it. What's there? Why unnecessary? Burden you, burden me, burden everyone. Withdraw it. If you don't want to press it. Yes. Mr. MS.
RS Deuri, my lord.
R.S. Deuri, learned counsel for the petitioner. Submits that on on perusal of the affidavit filed by respondent number 5. There's no merit in the matter, therefore she would like not to press this restriction. Mr.
My name is A. Narzari.
That's my lord.
As
For the private
does learned standing counsel. Her second, her education and Mr.
Number 5, my lord.
Respondent number 5.
Your name, please.
My name is A. Narzari, your lordship.
A. Narzari, learned counsel for the respondent 5 are present, huh? Accordingly, writ petition stands closed. Has not pressed.
Obliged.
Pleasure.
4 and 5.
May I please, your lordship?
Yes.
My lord, in fact, the instruction from the petitioner is awaited. Perhaps he may not like to press the petition further, but my lord, I am waiting for a written, my lord. So, my lord, can it be taken up on next Tuesday or Wednesday?
What is the matter?
My lord, matter regards selection and appointment in the Department of Vishwanath College in the Department of Philosophy, my lord. Though, my lord, I stand in the merit list, my lord, higher than the private respondent, I had been deprived, my lord. And thereafter, my lord, though agitation has been raised against the, my lord, private respondents, but it has not been acted upon, my lord. Therefore, I have come before my lordships, my lord. My lord, in the meantime, I have got the instruction that she has got a fresh appointment in Sibsagar College, my lord. In the same, so perhaps she may not like to.
We'll
press
close it,
continue.
We'll close it
No, my lord.
with a liberty to file afresh.
My lord, only difficulty nowadays, my lord, without written, it is risky, my lord. So that's why, my lord, I am submitting that.
See, your senior counsel,
My lord.
your the submission
My lord,
and the votes will be taken
I
as
know,
a
I know, my lord.
as a
My-
gospel truth or
My lord,
Khuda ki or Allah ki,
my lord, my lord. I am
something
not
like
on-
that. Is not
My
it?
lord, I have talked just now, my lord, and they are not, but directly with the petitioner, I could not contact, my lord.
Okay. Mr. Air Buya, senior counsel, submits that he has an information
Mal.
that the, he is an information that the petitioner, has been, what you said,
I have been, my lord, appointed in Sibsagar College.
yeah, he has been informed
see,
that,
my lord.
he has been informed that the
Mal.
petitioner has been appointed
Mal.
as assistant professor
Assistant professor.
in
Same
some
paper.
other college,
Mal.
some other college. Therefore, the petitioner may not like to pursue this matter further. Pursue this matter. Pursue this matter. However, he needs some time to take the written
Mal.
instruction from the petitioner. As expressed for listing of the matter after a week.
After a week.
Ah.
Mal.
Praise the Lord, this matter after
Mal.
a week.
Deeply obliged.
Expressed for, huh?
Item 11.
May I please, your lordship? Lordship, in this matter, petitioner is the eldest surviving wife, your lordship, claiming for family pension on the death of her husband, your lordship. Private respondent is the second wife, your lordship. She is receiving pension, your lordship, and there was an interim order passed by this honorable court, whereby a stay is granted with regard to the disbursement of pension, your lordship. Lordship, kindly see annexure 1, your lordship, page number 19.
What's the interim order?
Interim order on 19.3, I guess. Lordship.
Saying what?
Pension disbursement has been stayed, your lordship.
Parliament shall not release the family pension to respondent. Yes.
Now, your lordship, may I kindly see annexure 1, your lordship.
Yes. You are for,
Private respondent.
who is for the state? Who is for the state? Ready? Can it be disposed of?
Lordship.
Hmm? Parties are ready. Huh? Why I'm asking, because if parties are not ready, unnecessary hearing is not, I mean,
A date may,
will not hear unnecessary. Huh?
a date may be given, your lordship.
Okay. As agreed to by learned counsel for the parties, Mr.
R.H. Chaudhary, your lordship.
R.H.
R.H. Chaudhary, your lordship.
R.H. Chaudhary, learned counsel for the petition, and Mr. M.H. Lachkar, learned counsel for the respondent number.
Bank of India, no? Respondent number 6 and 7.
And you give their name, huh? All give, so you just give your name. Let this matter be listed after 2 weeks,
Any date, lordship.
3 weeks,
Pension matter, your lordship.
2 weeks or 3 weeks.
A date may be fixed.
3 weeks, give the name.
Right.
Item 14.
May I please, your lordship?
Yes.
Lordship, kindly have a glance at the last order for a moment, madam.
Last order.
My lord.
Lordship, in this matter,
Yes.
sent it for signing and waiting.
Hmm?
I'll be filing it today, madam.
Have you seen the last order? 25,000.
Lordship will kindly.
See, in the event the affidavit is not filed on or before 8/5, the said affidavit would be permissible to be filed on payment of rupees 25,000.
I will filing it today, my lord. Some,
Can
there was,
help it.
there was
Today is what?
some issue regarding.
Today is what?
Today is the, my lord,
You have to modify. I cannot modify this order.
today, my lord, because of the fact that, my lord, what has happened is, we had sent it, my lord, then there was
I
some
understand,
correction,
but
some
can't
correction.
help it. Also, the judicial order is there.
My lord will kindly,
No,
allow
I
us to
cannot, I cannot review this. Or I cannot modify this.
file it, my lord, by today, my lord.
We'll record that, but you have to pay. This
Maybe
judicial order is there.
that may be excused.
What
today.
can I do?
And,
You file an appeal against this,
lordships,
or they file a review. Very difficult. Heard, Mr.
Yes, Alim.
S.
Alim.
Alim, learned counsel for the petitioner. Mr. Epukan, learned standing counsel, elementary education department, submits that he has received the instruction. Yeah.
be filing it today.
He
During the course of the
received
day.
instruction. No, he would be filing the affidavit during the course of the day. Therefore, fresh for listing of the matter after a week. List of next para. Peruse the order dated 24/04/2026. List of this court. Having considered the matter, comma, allowed the learned standing counsel, elementary education, to file the affidavit on or before 08/05/2026. And in the event the affidavit is not filed on or before 08/05/2026, comma, the affidavits would be permissible, would be permitted to be filed on payment of rupees 25,000 before the registry of this court. List of considered above. No, please stop. In view of the judicial order passed by the coordinate bench as noted above, comma, the petition, the standing counsel, learned standing counsel, elementary education is permitted to file the affidavit on payment of rupees 25,000. List the matter after 1 week. Can't help it, sir. It's a judicial order.
May I pray for him for a date, my lord?
After 1 week, we'll see.
My lord. Deeply obliged.
I'm sorry, I can't help it. I cannot modify like that. All right. Because it was in your presence only order was passed while granting you a time. Huh?
We have sent it back. Therefore, we were praying, my lord, that today, my lord.
No,
if we cannot- if we
they
could file
said,
it today, my
they
lord,
said
then my-
earlier when the matter is taken up, no prayer was made. Only it was on 24 only you made a prayer. Anyway, I can't help it. Sorry. I'm sorry, but I can't help it. Or I'm sorry that I can't help you.
Item 15. May I please, Lord? Also, here the petitioner, he was nominated as the president of the school management committee, Lordship,
Yes.
at 35/22. Annexure 6.
What do you said?
Subsequently, his nomination was challenged before this court in a writ petition, Lordship, 4537 in 23. And subsequent, then the writ petition was withdrawn. And petitioner who took charge as president in its first meeting on 13/12/23, which was approved by the Inspector of School Durham. Then after 1 month, Lordship, he was removed. Is agreed, Lordship, and that order, Lordship, which we are challenging here is 21, page 21.
Yes,
The lordship will come to page 21.
21. Yes,
Is the order, lordship, which you are challenging.
consequent upon the adoption of non-confidence, no confidence motion against Muhammad Jinnat Ali by the members of SMDC of Jangalpur High School, the president is hereby released from.
Lordship, this honorable court, lordship, there is an order, lordship, I think.
Yes,
There is a previous order, lordship, where this court wanted to know the procedure for adopting a no confidence against the president of SMC.
of the SMC.
And they.
School Management Committee.
Yes, and asked the government to file an affidavit.
Hmm.
They file an affidavit, lordship, but there, nothing has been mentioned about that procedure.
Procedure.
Yes.
Yes, what is the procedure? For no confidence motion. What is there, you have annexed anything? Any proceedings, minutes or something like that?
I have annexed that.
Any minutes before the order is passed?
Before the order is passed, yes, lordship.
It's a notification, my lord, and except to page 22.
Hmm. Relevant.
And here, my lord. Selection process of vice president and president and vice president.
Where it is?
And page number 24, it's a last paragraph.
Selection of president and vice. The inspector of school of council and so and so, which within a. It should be.
This is only regard to selection, lordship.
Yes.
There is nothing in this with regard to adoption of no confidence motion, lordship.
Yes.
Since this petition is pending for a long time and the term of that committee is also going to expire, lordship, what I am suggesting, lordship.
You are continuing.
Can the matter be remanded to the deputy
You are
commissioner?
continuing.
Yeah.
Who is continuing?
I am not continuing, lordship.
Who is
Vice-
after
Vice President
after
was-
you were released?
Yes, vice president is holding. post.
Now.
Yes,
Tenure is for
for 3 years,
3 years.
No,
Now
my
it's
lord, it is
over.
Now 5 years.
5 years.
Yes. it
So
is
even
5
then, lordship, it was my
5 years is over now.
my nomination was in the year 22. So it will be
22.
over next
Huh?
year. It will be over next year, lordship.
And moreover, my lord, there are some allegations against the petitioner, my lord.
It's all right. We
Yes.
would like to know what is the procedure.
Lordship, in 1 month, what?
Is there any provision for no confidence motion?
My lord, regarding no confidence motion, there is no specific provision by, but my lord, regarding removal or termination, there is provision, my lord.
Where it is?
Okay, my lord, 2014 notification, my lord, is there. And it is also mentioned that,
But this order says consequent upon the adoption of no confidence motion against the president. What is that resolution?
Even I was not aware, lordship, that.
What is that resolution
my lord,
or the meeting?
yes, regarding that, my lord, deputy commissioner is the authority, my lord. Here, one partial modification was occurred, and in that partial modification, it is stated that school guidelines for the constitution of school management and development committee issued by government notification so and so dated 24/6/2016 and letter number ASC so and so dated 5/4/2017. The deputy commissioner is hereby empowered to select the president and vice president of the school management and development committee of an educational institution of concerned district with the approval of the guardian minister. So deputy commissioner is the authority here. Also, termination letter was issued by the deputy commissioner,
Under what,
district commissioner.
under what notification terminated? This is not a termination as such. He has been released
He has been released, my lord.
upon, consequent upon the adoption of no confidence, not allegation, page 21C.
Yes. No confidence motion, yes.
Ah, the
District commissioner is there.
as of now, we have understood deputy commissioner or authorities to appoint or constitute a committee and appoint a president. It can be terminated also. Authority power to appoint includes the power to terminate.
Yes.
General Clauses Act. That one could understand. But this release is posting him from the post of president is consequent upon the adoption of no confidence motion. What's the power? From where you have drawn this power?
Commissioner,
We,
they can explain my lord properly. District commissioner issued the letter.
Which
my
district
lord.
commissioner? Saikia,
My lord,
very cunning, Mr. Sharma. He's passing the buck.
In 2021, my lord, the department has issued a notification where, my lord, the deputy commissioner to empowered to appoint the president of the managing committee, my lord. The school will send 2 persons, he can appoint 1 person. And there is another notification, my lord, where the power given to the deputy commissioner that he have a right to remove the president also, my lord.
How it is removed? This is removal is on the basis of no confident motion. It is aligned to the and foreign to the your notification. There is no provision.
There is a clause, my lord.
Huh.
There is a notification, my lord. Right now, that notification I have not, my lord, I cannot place it. my
You are
lord.
party here.
Yes, my lord, yes, I am party here.
Then
No, 14,
there is a notification provision for provision no confidence motion.
yeah, my lord, including termination and all, my lord.
Termination, it's okay. No confidence motion after that consequence will follow.
He have not confidence upon the president, my lord, definitely he have to remove, my lord.
What is that provision?
Even, my lord, is not.
See, no confidence motion is this words and praise. It's not that easy. It has a consequences. It has a bearing.
Because, my lord, this president.
It's just
is not
that
an appointed
it's just that I don't have a confidence. Therefore, you'll be removed. It's not that. When there is a no confidence motion, there must be you have to have a power. From where you have what is the source of power to have adopt
My lord,
a no
therefore, I am
confidence
saying, my lord,
motion?
deputy commissioner can nominate it, my lord. He is the not a appointee, my lord. He has a no right like appointee, my lord. Deputy
Then how
commissioner nominated one
you may
person.
have the power to even if there's a even if no explicitly provided under the notification. If he has the power to appoint, he has the power to remove also. But then the procedure of removal,
It is not a specific procedure, my lord.
then why you have adopted the no confidence motion, allowed to have a no confidence motion?
Deputy commissioner, because he is not appointed, he is nominated, and that nomination also satisfies.
There must be something. You said
As parent member, my lord.
how
So
to
his
remove it.
engagement, they are not
Do you have the
supposed to show.
documents to show that it can be removed? President can be removed.
But there is a notification.
Where? Have you not filed the affidavit?
No,
Have you not filed the affidavit?
I am not filing the affidavit, my lord, that.
Because it's your the
Inspector-
impure order is passed by you only.
My lord,
Why you should not file an affidavit?
my lord. Will file, my lord. Because I understood the query of this, my lord, and that provision should be cleared. Will file, my lord. 3 weeks time may be granted, my lord. Within 3 weeks, we will file, my lord.
Who has filed the affidavit?
Inspector of schools file an affidavit, my lord.
The affidavit and the director filed it.
What they are saying?
Inspector of school, my lord, he has stated the notification, my lord, issued in 2021, where deputy commissioner was empowered to be nominated the president, my lord.
Hmm.
Basically, my lord, that notification, my lord, enclosed.
There's no source of power. We'll set aside this order.
Now, my lord, because that issue, that is the adoption of the law. My lord, may please give an opportunity so that we can also bring before this honorable court that we has a power.
Where they stop you? Did we? Did you stop from filing affidavit?
If Lordship will turn the pages, Lordship will find how many opportunities have been given to them.
It's not an isolated case. It's not sir, it's not an isolated case.
Yes.
Okay, 2024. Last opportunity. Heard, Mr.
M. Ahmed.
Learned counsel for the petitioner.
Will you sir?
Although the affidavit on behalf of the secondary education, on behalf of the Director of Secondary Education and Inspector of Schools have been filed, the Deputy Commissioner who has issued the impugn order is yet to file the counter affidavit. This stuff is read for by Mr. S. P. Seke, Learned State Council for the respond number 3, Deputy Commissioner. For the Deputy Commissioner, Darang District. District Commissioner, Darang District. Respond number 3. And considering that the petitioner appears to have been removed from the post of President of SMDC upon adoption of no confidence motion, 3 weeks time is granted to Mr. P. Seke, Learned State Council to file the affidavit, counter affidavit, clearly indicating the source of power of removal of the president and the provision of and the procedure, source of power and its procedure for removal of the removal of the president's rights of the SMDC. It is also including the provision for no confidence motion, if any. This matter after 3 weeks.
A date can be fixed, Lordship.
May I please, Your Lordship? My lord, the present petitioner was an LDA.
Instruction was thought for that instruction is I record. Full for is allowing him to serve in the UTL. And without prefixing his pay and scale at the scale of LDA instead of UTA.
Yes, here.
Order dated 27/11/2025 may kindly be seen for once, Lordship.
27? What is this instruction?
Instruction, I have already placed, Lordship. I will inform then, Lordship. This honorable has recorded the entire case of the petitioner.
27/11.
27/11.
Informed that petitioner himself had been drawing excess drawal amount without non-fixation of so after being reverted with under the jurisdiction of then principal in charge of so and so. What instruction is this?
Lordship, in this case, petitioner was reverted from UDA to LDA, Lordship, on 2008, Lordship.
Yes.
Thereafter, he has been enjoying the pay of UDA. Despite the
That's why who is the responsible?
Yes, that's why the last instruction, today's instruction, Lordship,
Huh.
the one on the basis of the report, Lordship, we have held that he was the person who is the responsible, Lordship.
How?
He was the LDA, he was
He is a DDO.
Lordship.
He is
has-
a DDO.
Lordship, in a school.
He is a DDO.
Lordship, accordingly, Lordship, may I read, Lordship? Accordingly, Inspector of School, Hailakandi, by letter dated, informed that petitioner.
That's why I'm
himself-
surprised. How can you just blame him? Obviously, he's there.
No, it is.
He has received it.
Yes.
He cannot
He
be
has prepared the
himself.
bill.
Huh?
He has prepared the bill.
Huh?
In a school, Lordship, LDA and UDA has done everything, Lordship. In his school, Lordship, he was the reverted as a LDA, but he functioned as a UDA, Lordship. And he has prepared all the bill and placed before the headmaster, Lordship.
So it is not the duty of the headmaster or authority to check it, to cross check it.
He will also look into that aspect, that dereliction on the part of headmaster, but he cannot be escaped from his liability because he knew that what he has been receiving, Lordship. It was not out of his knowledge. He has prepared.
That way I've understood. He knows. But there is an authority, DDO and everything.
Yes.
Higher than he, even if he prepares, is it not duty to cross check?
It was duty, Lordship.
Then you just can blame him alone. You are
Lordship.
not blaming anyone. You just, he himself is.
And we have recently, Lordship, under the jurisdiction of the then principal of the government of school, Lordship.
Ha.
We have not giving the Scott fee the principal also, Lordship. We will also take him departmentally, Lordship. But for the benefit, the petitioner is entitled to paying before. his court.
What is your grievance here?
My grievance. is
Your
that-
your petition appears to be a fraud,
No,
total fraud.
that is the correct way.
No, when you were reverted back in 2000, how can you draw the pay of UDA?
But actually, I was appointed as LD. Thereafter, I filed case in High Court, and pursuant to High Court order, I was promoted. Then another person came and filed another case.
Then reverted back.
There I was reverted. But all along, the authorities took from me the service of UDA.
Doesn't matter.
But then, my
There's
lord,
a judicial order. You have been reverted back.
no, judicial order means, my lord, that was reverted by the executive authority.
Right? On
Not
the
the
pursuant
judiciary.
to the order of the court only.
Let me, let me submit, my lord. Now, in 2019, I have retired. And thereafter, they are trying to take one plea or another plea to deprive me from my pensionary benefits, and they want to deduct the amount.
What is the effect? Whether you
Now-
have drawn the scale of pay, a scale of pay of UDA since 2008 after reversion.
My lord, the Honorable Supreme Court is very much clear, a category of judgments are there, that for that party, no recovery can be made from the party, and there are so many judgments.
I am
of the-
sorry, I'm sorry,
So many
I'm sorry.
No, no, my lord. I am-
When there is no fault on the part of the,
No, because my learned friend said that I prepared the bill, that is not correct. There are 4 UDS.
forget
Four
about that.
LDS.
Preparation, let us not accept that his submission. You may not have prepared. But facts remains that pursuant to the order of this court, you have been reverted back to the LDA. Since 2008 till retirement, you have drawn and you received the pay of UDA.
Not by the order of.
You
this
may
court.
have been allowed to work as a director. It doesn't mean that legally you will be allowed to, you will have a right to draw the or accept the pay
All
of
these
director.
Points have been answered that in case of LDA, all these points have been answered by the Honorable Supreme Court
Sorry,
and said, yes, my lord.
sorry.
Then
Sorry.
No.
Sir, I have a considerable knowledge of the
my
law,
lord,
law later, but Supreme Court also.
story should be followed by legal maxims.
Yes.
Legal maxim is in my favor.
What is legal maxim?
Yes, my lord. Yes. Actually, earlier I have given judgments. Yes. And let's see para 59, my lord. Para 59, under the excess amount that has been paid to the appellant, teachers was not because of any misrepresentation or fraud on their part. And the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled to.
So you didn't know that what is your scale of pay
Because
as a LDA?
my lord, my principal has always.
What what do you try to say? It's completely.
Principal's long.
What is the principle here?
Long letter.
What is the principle here?
Principal.
What is the legal maxim here?
Yes.
Sir, what do you mean by legal maxim?
60.
What is the legal
Page
maxim?
60.
Page
60 and 61.
Yeah. What is the legal maxim?
Learned
Tell us.
Counsel also submitted that prior to the interim order passed by this court on 7/4/2003 in the special petition, thereby the order of recovery passed by the division bench of High Court was stated some installments amount had already been recovered from some of the teachers. Since we have directed that no recovery
Wow.
of the excess amount. be
Mr.
made
Mohammed,
from-
is it a legal maxim? Is this a legal maxim?
Well, let me read.
Nothing. You have said you are supposed to show me legal maxim.
See, here, my lord, order of the Supreme Court cannot be bypassed by any authority.
Is it called
within
a
the
legal
territory of
maxim?
India.
Is it a legal maxim?
And there are, I'm coming.
Mr. Mohammed, is it a legal maxim? The judgment of the Supreme Court is a legal maxim.
This ratio of the case, my lord, I am coming one after the, my lord, kindly
You are
here.
supposed to show me legal maxim.
Yes, there are also.
So a legal maxim when a the LDA
Here, the Honorable Supreme Court has set aside the order of the High Court.
LDA illegally accepted the salary of scale pay scale of pay of UDA higher post despite he
No,
being
but-
reverted back to the LDA
Kindly
his
see the
original
order-
post.
Kindly see the order of the principal.
Ah.
Principal has given a long description.
Doesn't matter
what-
because he has collided with you. Principal, because of the principal, we're not going to spare them also.
No, let me submit, my lord.
I am asking, sir, you know that you have been reverted back in 2008, right? Till your retirement, are you getting my point?
No,
Are you getting what I wanted to tell
there
you?
cannot be any recovery.
I'm just asking the facts. I just wanted to know the facts first.
Here, 13 conditions have been made, madam. Kindly see this. This will make it very much clear. I am satisfied, your lordship.
No, you cannot. First, tell us the facts. Simple facts, I just wanted to know. You know that you were reverted back in 2008.
That I know.
Thereafter, you have
But my
accepted.
service was taken as.
Just wait,
PPA.
let me complete my sentence. Hold your horses. You know that you have been reverted back to the post of LDA, right? Since 2000, in 2008. Thereafter, knowing fully, you have accepted the pay of UDA.
Because I discharged the work of UDA.
Where is any order to allow you to draw that pay?
Yes, I was drawing. I was doing.
Any order to say that since you are, although you are LDA, but then discharging the function of UDA, therefore you are entitled to have the scale pay of.
There is no such order, but principal allowed me.
Otherwise, that's
Allowed
illegal.
me. My immediate authority allowed
There
me.
is a collision between
can
you
you-
and the principal.
Kindly see this.
You
This-
prepared the bill, I mean the pay,
I
and
did
then
that. I definitely
approved by
was one of
the TDO.
Well, definitely I was one of the clerks, but I was not the clerk who prepared the bill, because there are 4 clerks. Can you see this? Para 18. Para 18, can you see?
Read it.
No, you will satisfy.
Read it, please.
It is not possible to postulate all situations of hardship which would give an employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of their entitlement.
All, please,
Read that as
please,
it
please,
may.
please. What is said? Read the last sentence.
It is not possible to postulate all situations of hardship
Yes,
which should govern employees on the issue of recovery,
yes.
where payments have been mistakenly.
Mistakenly. Is it mistaken?
I am coming, my lord, one after another. So let me give the full stop.
That's why I'm saying indicated. I have
Then last
I have a
time-
considerable knowledge of what the Supreme Court judgment is all about. I may not be in the fingertips,
But-
unlike you, but I have the.
No, I do not say. I am only interested with my client's legal interest. So there are some positions, criteria when it can not be curtailed. Can you see those, the following few situations wherein recoveries by the employers would be impermissible in law. Recovery from the employees belonging to class 3 and class 4 service. So I am class 3, madam. I am class 3. This is maximum Supreme Court value. This Supreme Court judgment, it cannot be forsaken by under any pretext. Let me satisfy your lordship. Then recovery from the retired employees or employees who are due to retire within 1 year of the order of recovery. Recovery in cases where an employee has wrongfully been required to discharge duties of a higher post and has been paid accordingly, even though he should have rightfully been required to work against an inferior post. So what do your lordship desire much more than this? All the answers have been given by the Honorable Apex Court. No recovery from grade 3 employee, no recovery if he has 1 year of service or has retired, or another wrongfully he has acted in a duty, then his due duty, that is in place of LDA, he discharged duties as UDA. So this is the law of the land, my lord. This is the law of the land because this has not been struck down by any of the authority of the Supreme Court, my lord. It is not yet struck down, at least 2
See,
minors,
I'll just tell you,
my lord.
it may be a long judgment, so many paragraphs.
This Supreme Court judgment, I am simply reading, my lord.
Simply, if the employee is allowed to draw without his fault, number 2, even if it's excess. All right.
No,
And-
no recovery can be
And
made.
there's no fraud, nothing. Here is in your case, you knowing fully well that you are not entitled to draw, still then you have accepted in collision with the principal, who is the DDO. Therefore, it can be recovered. We'll distinguish that.
My lord, kindly fix another date, I will say your loss.
No.
Can-
These are the only laws. There's no other laws which we have relied on.
No, but-
1, 2, 3, more than enough. One is enough.
My lord, actually, I'm sorry, from court number 3, I am being told again and again. So another day, my kindly for the hearing day, let me say it's your lordship, my lord.
I've heard you.
No,
Nothing is there.
lordship has heard me, but I have yet to be submitted.
I'll record all your submission and the judgment which you have relied on.
My lord, even then, lordship, if your lordship desires, it may also be kept further. I have no
See,
objection.
Mr. Mohammed, there's a saying in Hindi. You are comfortable with Hindi?
To some extent.
जितना देखता है उतना बुद्धू तू हूं नहीं. Right?
I don't say this, my lord. That is your lordship adoption.
It
I am not saying
it may apply to me equally. It could apply to you also.
Perhaps that also applies to me also. Though my hands are short,
So you remember.
it also applies to us.
You remember this.
Yes, I know.
जितना देखता है
And
या
I also know the
जैसे
story
देखता है उतना बुद्धू तू
of
हूं
a
नहीं.
judge who said that you don't think, a lawyer said to his judge, you don't think that I am as foolish as you.
And
That was also the criteria of a
another saying in Hindi. Waqt, time.
kindly allow another
Time.
statement.
That's what I'm saying. I'm asking. I'm just, they're thinking it. Waqt, what do you mean by waqt? It's a time. वक्त और इंसान की कदर किया कदर कर लो जनाब. ये दोनों सुना है, ये दोनों चले जाते हैं. Understood?
I understood. So accordingly, let my case also go. I have grasped 3 of you, my lord. Why your lordship is so hard on me?
No, I'm not hard on you. I'm hard on the litigants. The litigants who play fraud with the public money, right? Will put the hardest of the
In excess of
hard.
doing something, I am taking public money, not freely. I have been given nothing freely.
You should get what you are entitled.
Well, kindly fix another date.
It's the total
Kindly
fraud.
fix another date.
We'll keep
Today
it part
I have
hard.
9 hearing matter.
We'll keep it part hard.
No
Heard
problem.
Mr. M. Mohammed, M.U. Mohammed, learned counsel for the petitioner, and also heard Mr. P.P. Datta, learned standing counsel, secondary education.
And their mistake, lordship will also say what they have done with their officer. They
After
are on me with sword, but they are doing nothing against their officer. That lordship would also kindly.
heard in part. No, you just said after arguing the matter at some length, when this court, when Mr. Mahmood, on being confronted with the judgment judgment of the Supreme Court he has relied on with press for some time to address this court, and therefore press for listing of the matter after 2 weeks. 2 weeks, please stuff. Since the matter has been heard at considerable length, it would be appropriate to continue it would be appropriate to keep the matter part heard while granting time to Mr. Mohammed to for 2 weeks to address this court in the matter.
Obliged. I am thankful, sir, for giving me so much time.
वक्त का कदर करा, वक्त का कदर कर लीजिए.
Obliged. Thank you.
Lordship is compassionate matter, Your Lordship.
Yes.
Only thing is that, Your Lordship, petitioner's case has not been considered. And in this regard, Your Lordship, state respondent has answered page number 69, Your Lordship. of
What is your case?
Lordship, he applied for consideration on the death of his father, Your Lordship. That has not been considered, Your Lordship. Page
By-
number 69 of the affidavit opposition is clear.
69.
69, Your Lordship, para 11. Affidavit opposition, Your Lordship, page number 69.
Yes.
Para 11, Your Lordship, that with regard to the statement made para 11 of the deponent begs to state that the case of the petitioner has already been submitted by the Inspector of Schools, Hailakandi, by his office letter number so and so dated 6/9/24 for placing the matter before the next available DLC. But the DLC Hailakandi could not be called for as the Gauhati personnel B department has issued OM dated so and so 18/9/24 for which the pension petitioner case is pending at the level of DSCLA. Only thing is that, Your Lordship, that OM has come, Your Lordship. Let them consider, Your Lordship, and on its own merit and decide, Your Lordship, as per law, Your Lordship. Only thing, because the writ petition was filed, Your Lordship, 5/8/2024, and that OM has been interfered with in WBC number 3/4/2025, where a cutoff date was set as 4/4/2025. On or after that, any writ petition has been filed, OM will cover, Your Lordship, but prior to, before that, Your Lordship, that OM will not come so far as consideration part is concerned, Your Lordship.
So,
So let the matter be sent, Your Lordship, for consideration as per law on its own merit, Your Lordship.
hmm?
My prayer is limited for consideration, Your Lordship,
Yes.
as per law on its own merit, Your Lordship.
My lord.
No, it is no longer, they don't have the scheme. The scheme is done away, it is when your father died,
Yes, ma'am.
91, my lord.
hmm,
He said, my lord, that immediate.
1999.
91, my lord. Now he's
But
coming
it is to be
2024, my lord.
decided by the DLC, Your Lordship. Only thing as so far as their statement in the affidavit of opposition.
When did you apply?
2005, Your Lordship. I was minor.
And your father died in
I
1991.
was minor.
Huh?
And in between, Your Lordship, my mother also applied, Your Lordship. That has not been considered, and on attaining the majority, Your Lordship, I have made an application, Your Lordship.
I'm not inclined. Heard Mr. So-and-so, try before you think about it. Learned counsel for the petitioner and also Mr. So. As prayed for by Mr. So-and-so, Chaudhary, learned counsel for the, list this matter after 4 weeks.
Obliged, Lordship.
Think about it. We cannot just simply direct it place before the DLC. 1991.
Presently for immediate.
Obliged, Lordship.
Here in this case, I need some time to file affidavit, my lord. The instruction not received yet.
Yes, heard
Yes,
Mr. So-and-so, learned counsel.
Hello, in this case, my lord, yes.
On the prayer of Mr. S. Das learned standing counsel and execution. Further 3 weeks time is granted by affidavit.
Date may be fixed, my lord, 2000.
3 weeks, give the date.
Huh? Obliged.
I apologize, Lordship. I understand in this case, Lordship, we have taken multiple occasions and to submit our affidavit of opposition, Lordship. However, in the first case, we have submitted, but in the second case, which is the penalty, Lordship, that we have imposed, that has been challenged by the petitioner. In that case, we are still have to file our affidavit, Your Lordship.
Lordship, last opportunity.
Heard Mr.
Atria, Lordship.
Air
Atria, Lordship. Atria.
Atria,
Yes.
learned counsel for the petitioner. Petitioners. Petitioner, huh? Mr. So it's DJ Das, learned counsel for respondent number 1, 2. Submits them. He may be granted a last chance to file affidavit in reply in WPC.
285 of 2025.
28. You have filed here.
We have not filed in this case. We have filed only in 6037/2022.
It's 285 of 2025. Considering that the matter, considering the nature of the matter, nature of the, considering the issue involved, come on. The 3 weeks time is granted to Mr. Das to file affidavit as prayed for as a last chance. Last chance, huh? Last chance, 3 weeks.
Some instruction.
3 weeks, give the date.
Item 25.
Here would like to file our affidavit, Lordship. It matter regarding.
N. Sharma, Mr. N. Sharma, learned counsel. On the prayer of Mr. P. N. Sharma, learned standing counsel, elementary, secondary or elementary?
Elementary.
Elementary Education Department. 3 weeks time is granted to file.
My lord,
This
matter-
after 3 weeks.
let the matter be listed along with prohibition number 2140
List the matter along with WPC
2140 of 2025.
2140 of 2025.
Date may be fixed. Date.
3 weeks.
Problem.
Item 26.
May I present? Lordship, in this case, Lordship, I have challenged the final gradation list, Lordship, which has been prepared, Lordship, totally violating the procedures, Lordship, prescribed procedures, Lordship. In the draft gradation list, there were, Lordship, 700.
Yes, affidavit has been filed.
No, Lord.
Huh? You don't want to file affidavit? You don't want to file?
And we require 2 weeks of time to file the affidavit.
Or Mr.
AMS Majumdar.
MS Mazumdar, learned counsel for the, on the prayer of Mr. MS
Ahmed.
S. You are S. Ahmed. Are you S. Ahmed? Just take that.
On behalf of S. Roy.
S.
S. Roy.
Who is S. Roy?
Lordship.
For whom? For respondent number?
Number Lordship 5, 6, 7, and 8.
Private
They are
respondent.
private.
Who is for the state? Why you are not? You have filed. Then you don't want to file. So record it. Only prayer of so and so, so and so. Both have. Standing counsel
Yes, Your Lordship.
for
Secondary education.
secondary education, standing on secondary education and MS so and so appearing on behalf of respondent number 5 to
8.
5 to 8. 3 weeks time is granted. Further 3 weeks time is granted to file affidavit in opposition. Huh? This after 3 weeks.
Lordship, a date may be fixed kindly, Lordship.
Then 4 weeks. No, give the date after 4 weeks. List after 3 weeks, but give the date after 4 weeks.
Obliged.
Item 27.
My lord, affidavit of respondent number 5 is necessary, my lord. Affidavit of respondent number 5 is necessary, my lord.
Yes, who is respondent number 5? NCT. NCT, UGC,
NCT major.
NCT.
3 weeks time may be granted.
Huh?
3 weeks time may be granted.
Heard, Mr.
Yes, how?
Yes, I who learned counsel for the petitioner, as pressed for by Mr. I Alam, learned counsel for the, learned counsel, the standing counsel, NCT.
My lord, kindly.
Further 3 weeks time is granted to file affidavit in opposition. Next,
My lord, kindly continue the interim order.
interim order passed and let's continue. Interim order is there.
Yes,
You are not filing.
They have filed my.
Then you write, Mr. PN has, PN Sharma, standing counsel, elementary. Submits that he has already filed the affidavit, counter affidavit on behalf of the state.
Item 28.
May I please, Lordship?
Yes.
Isn't it for non-payment of arrears, Lordship?
Ah,
Last occasion, the secondary education is directed to take instruction.
Yes. Yes.
Lordship, we may be granted some more time, your lordship.
Lordship, they have already given a full time. Lordship, may kindly peruse last order dated 8/4/2026.
Secondary education. Yes.
We may be given some more time, your lordship.
Have you seen the order of 8/5? Then
Yes, sir.
there's no dispute about the entitlement. About his,
Lordship, 10 days time, your lordship.
huh?
10 days time, your lordship.
Will direct you to pay within 15 days.
Yes, sir. Yes, Lord.
Also.
Next, heard Mr.
This, yes.
Learned counsel for the petitioner. Just give you 1 week. 1 week time. Next parent. Matter pertains to what is this amount?
9,14,308.
For what?
He was suspended.
Area salary.
Area salary. For non-payment
Pertains
of-
to non-payment of area salary amounting to rupees 9,14,308, which is parenthesis, which has been settled by the respondent authorities in favor of the petitioner, Christopher. Parenthesis, there appears to be no dispute as regard the claim of the petitioner. Listen, it is no dispute to the claim of the petitioner, except that since the school under which the petitioner was working has been amalgamated to other school, the approved authority, either elementary education would be either elementary education department, secondary education, list of this court. By an order that having considered the issue and observed that whether the authority concerned would be elementary education department or secondary education department, if the amount is indeed due to the petitioner, same cannot be an excuse. Accordingly, directed the Learned Standing Council, secondary education department to obtain instruction. However, MS today, MS H. Tarangpe, Learned Standing Council, elementary, secondary education, pressed for a short so that the necessary instruction as directed by this court would be obtained. List of considering the issue involved and the considering the submission of learned counsel for the parties and also considering the issue involved in this matter. A week's time is granted to MS therapy to obtain instruction as allowed by this, as directed by this code on 0805/2026. One will. Yes.
Here in this matter, I am told by Mr. S. Bora, London Standing Counsel for the SSA, they have filed their affidavit perhaps today.
Today I have
Today,
received your
today.
So,
phone number 2 and 4. I have received the copy today. So I
Yes.
shall file reply.
okay. Mr.
Listed
So and so,
RM Chaudhary.
RM Chaudhary, Land Counsel for the petitioner. Press warrant is granted. 2 weeks time to file affidavit in reply. List the matter after 2 weeks.
That may be fixed.
Item 31. Lord, here, my lord, I have received a parawise comment, my lord. I want to file our affidavit, my lord. 2 weeks time may be granted.
Heard, Mr.
NH Borwian.
Land Counsel, no, Mr. NS Barua, Land Counsel petitioner is present. Next para, Mr. PK Barua, Land Standing Counsel, Elementary Education submits that he has already received the parawise comment. Therefore, press for 3 weeks time to file affidavit in opposition. This prayer is allowed. This is matter after 3 weeks.
Item 23.
My lord, earlier we filed that for contempt case against 2 persons, but later on it was discovered that only respondent number 1, that is contender number 1 is holding the post, who will implement the order of the honorable court. So I have taken a step on him. I don't know. Respondent will be listening to you. Respondent will get it.
Till that no ID card or answer notice returned back from respondent number 2.
We have taken steps.
Respondent number 2 or respondent number 1?
1. Now only case should run against 1 only.
No, we're talking about the steps you have taken in respect of respondent number 2 only. Who is for 1? Anybody appearing?
1 also I have taken. Against both the contenders we have taken steps, but later on respondent number 2 was struck off, then 1 only remained.
1 is who? Secretary to Government Elementary Education.
Well,
There's no indication about the respondent number 1. It's all about respondent number 2 only.
no, we filed the IA and that was allowed, my lord.
For what?
Implement petition we filed on 2/12/24. Then we were asked to take a step on respondent number 2 and we have taken the steps.
Who is respondent number 2?
Manjit Brahmo.
He's been shown as
No, Manjit Brahmo is respondent number 1. 2 is Narayan Kaur. Now case should run only against 1.
Manjit Kaur.
No, Manjit Brahmo.
Brahmo.
Yes.
There's no indication about the respondent number 1.
But we have taken steps, the registry has accepted it.
This is only about. It is submitted by Mr. M.U. Muhammad, London Counsel for the petitioner, that steps have been taken in respect of respondent number 1, namely Manjit Brahma.
Yes. It is taken on.
However, it is noticed that
24/11/25.
no noting is noting is mentioned, no noting is recorded, no noting is maintained as regards the service of notice upon respondent. It only recorded the steps as regards respondent to only. Next para. Registered to verify. And do
That we can leave it
do the
written,
need. List after 2
24
weeks.
11 to 25, we have taken steps.
I've directed registry to. There's nothing. No noting. No noting in the file.
As per the order dated 6/4/25, service is already complete and they were given time to file their affidavits.
Yes.
No affidavits. they are not
We'll file it
filed.
in 2 weeks also. We have received the instructions also.
It's for admission after 2 weeks.
Or Mr. So-and-so.
BJ Mukherjee.
Huh?
BJ Mukherjee.
BJ Mahajan.
Mukherjee.
Mukherjee, learned counsel for the petitioner. Service complete.
Service is complete.
I'm preparing for 2, 4 and 5 year lordship.
Then who else?
Private 6 to 13 accepted.
Granted 2 weeks time to file affidavit, huh? All of them.
It may be fixed for admission there.
List the matter for admission.
Secondary education.
Are you filing affidavit? You have filed? Then why you kept quiet? Record all their name and granted 3 weeks time to file affidavit, huh? File their respective affidavits. Counter affidavit, please.
Well, this is contempt proceeding alert, non-compliance of the court's order. Taking little accommodation of 2 weeks, my lord. What had happened on last occasion also I've submitted, my lord. One appeal was filed, my lord. Thereafter, subsequently, some objections raised by the registry. Although steps has been taken, my lord, steps has been taken for rectifying the objections, my lord. Now, I'm waiting for the listing of the matter, my lord. Kindly.
You have filed the affidavit.
No, not affidavit, but that was the typing mistakes there in the order. It should have been appeal, my lord. Appeal. I have filed an appeal.
It doesn't matter. His law is very clear. Until there is an order, interim order, you cannot, just because you have filed an appeal.
Yes, yes.
Just grant them sometime.
No,
You are for?
No, but that's all contempt. No, only 2
But fixing it after 2 weeks?
One thing I will submit here. Well, there is a notification of this court, my lord. If appeal filed and it is defective, pending for more than 3 years, it will become infractional, my lord. There is notification, my lord. And this appeal was shown to have been 20.
See, law is very clear. Even if the appeal is filed, until that time there is an interim order, it cannot, will proceed with the contempt. Right?
My lord,
Are you getting me what I am trying to convey to you?
my lord.
Forget about that. Law is well settled. Even if the appeal is filed against the order alleged to have been violated, all right, alleged to not been complied with, unless there is an order of the higher court, interim order, staying that order, the contempt proceeding will proceed. They have to comply.
Yes, that is correct.
Therefore,
In this case, my lord, the appeal was not yet listed, my lord. They did not rectify the correct.
even if it appeal is filed, that's what I'm saying. Are you getting what, sir?
Yes.
Then why not granting it for just because you are filing an appeal? Just granting you to some time to take steps to comply with the order without recording it.
Yes.
Heard Mr. So-and-so, learned counsel for the petitioner. Mr.
Yes, that's my lord.
As thus learned counsel for the alleged contempt is granted 2 weeks time to take steps as regards the compliance of the order of this court.
What a date may be given, my lord.
2 weeks, just give the date. Yes.
There will. May I please, Your Lordship? Lordship, in this, both this writ petition, Your Lordship, dispute regarding the regularization of office assistant of Gauhati senior mother. Pleadings are complete, Your Lordship, but the respondent are yet to file the private respondent yet to file the affidavit in opposition.
Huh?
Respondents, private respondent has already appeared, Your Lordship. What I am praying, Your Lordship, let these matters may fix for admission on 9th of June, Your Lordship. Because
Pleadings are complete.
complete.
Pleadings are complete. Heard Mr. So-and-so learned counsel for the petitioners and also an MSP Das learned standing counsel elementary, secondary education as well as for respond number.
One, private respondent number 1. Private respondent number 1, she is appearing. On 9th June, Your Lordship. Okay.
List of pleadings are completed. List for admission after 3 weeks.
The date may kindly be fixed because your petitioner is on the verge of retirement, Your Lordship.
Okay. 9 June, 9 June.
9 June.
He said 9 June.
Much obliged, Your Lordship.
I am for respondent number 5, Your Honor. Today itself, I am going to file Wakalat number for respondent number 4, Your Honor. So I am praying for 4 weeks time to file our Wakalat number as well as our.
Heard Mr.
I,
I Hassan learned counsel for the petitioner. Who else? Affidavit state
I'm seeing some time.
Mr.
High.
A High learned counsel enters appearance on behalf of
Number 4 and
respond number.
respondent number 5, I am going to.
Respond number 5. List of, as per for the learned counsel for the respondents. Let this matter be listed after 3 weeks. For admission. For admission in the meantime. And at least this matter after 3 weeks for so as to for filing affidavit, counter affidavits. List of list the matter for admission hearing
A date may kindly be fixed, Lordship.
after 3 weeks.
Obliged, Lordship.
Well, resume.
Hearing item 39.
Why?
My senior is on the way, madam.
Who is your senior? For whom? For whom?
PKD, I'm senior.
Respondent?
Respondent Borden University.
Boroland. Boroland University.
Yes, madam.
Who has to pay?
Yes, my lord. Basically, this-
Boroland University has to pay.
yes, madam.
Any medical rules applicable, my lord,
Huh?
for payment, my lord. My lord, senior will, my lord, submit, my lord, sometime. My lord.
After some time.
It's taking over. It has.
Item 40.
My lord, my senior is on his way, my lord. It just take a couple of minutes, my lord. He's just on his way.
What is the matter about?
My lord, the matter pertains to provincialization, my lord, of the petitioner, who is a librarian, my lord. Just on his way, my lord. Just a minute, my lord. I'll just double this quote for just a minute.
Who are you? Mr. Abedin?
I'm for the principal of the institution, madam.
Okay. So you what is your stand? You say that he's entitled to be considered. Then what is the stand of the state?
Our stand is, he is not entitled, my lord.
Why?
Mr. K. Gogoi will argue, my lord.
Huh?
Mr. K. Gogoi will argue, my lord.
Where is the K Gogoi? Why he's not entitled? Why is not entitled? Librarian cannot be provincialized. Why? Principal says this can be provincialized, entitled to be provincialized.
I'm sorry, my lord, we did
Right, sir.
we had to reach so
Hmm.
fast, that's right.
Very simple matter. You are seeking provincialization of service as a librarian.
Yes,
Under what provision?
file is coming, my lord. That's a well.
Just show us the provision, that's all. We'll consider.
For my.
Provision with this, 2018. If I don't have a housing.
Oh, this is a, it's in a, that has someone kind of, but it just, the act right here. It ever,
One file to move the amount of whole. All of the relevant provision. ಈಗ ಒಂದ್ ಟೇಬಲ್ ಕೊಡಸ್ the provision your worship may kindly peruse. That is, my lord, Assam Education Provincialization of Services of Non-Teaching Staff Act 2018. That will be at page 92. Should be at 92.
Page 19.
92, my.
92.
No, of the my lord book.
Acha.
Section 4.
2018 Act.
Section 4 of the 2018 Act.
This is 18 or 17? 18.
2018.
18. Section 4. Non-teaching staff.
Non-teaching staff to government servants. May I read it, my lord? Subject to fulfillment of all the other provisions of this Act, the services of the non-teaching staff of all the venture educational institutions eligible under Section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in official gazette for the provincialization of the services of teachers, tutors of the school, college, and they shall become employees of the state government with effect from such date. Further, their services shall also be utilized in this school where the services of teachers, tutors of the school are utilized. This provision is important, my lord, provided that where the number of non-teaching staff serving in such venture educational institutions exceeds the number as specified in the schedule, The provincialization of the services of the employees shall be on the basis of seniority of service in the respective category in the concerned educational institutions. The state government shall have no such liability whatsoever in regard to such excess employees. Then two, the employee to be provincialized under this act must have been working in the concerned venture educational institution that have been recognized by the competent authority on or before 1/1/2006, must have minimum educational and professional qualification as laid down under the relevant service rules of as on 1/1/2011, must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institutions, which must be on 31/12/2010 or prior to that date. Now, my lord,
So non-teaching staff,
my lord,
definitely section 2E includes the librarian.
Right.
And the provincialization can be made of the non-teaching staff under section 4.
my lord.
Deemed to have been provincialized. What is section eligible for selection of education?
Now, if you
Section 3 is also important, I think. Section 3 also.
Section 3 is also relevant, my lord.
Hmm. So what is the facts? So these are the provisions.
My lord,
These are the provisions.
these are the provisions, my lord, and I fulfill the requirement under these provisions.
Okay.
Now, my lord,
You just tell us the facts.
my lord, the petitioner was appointed, my lord, by GB's resolution on 3/12/2010,
312.
my lord. That is as my lord, assistant librarian.
Hmm.
3/12/2010, your lordship finds at page 32.
Yes.
He joins on 10/12, my lord.
Hmm.
Joining letter is at page 33.
Okay. Next.
Then, my lord, he was granted study leave
Hmm.
by the, my lord, governing body. And, my lord, after the study leave, my lord, he completed his master degree in library science. And he rejoined back, my lord, after the study leave.
Hmm.
Then, my lord,
In which year?
my lord, he was on leave, my lord, from 2010 and 11, joined, my lord, on 1/8/2011 again.
Hmm.
Then, my lord, the governing body has decided to fill up the post of librarian. My lord, your lordship will kindly notice my appointment was assistant librarian,
Hmm.
because that may be relevant. And, my lord, the GB decided to fill up the post of librarian.
Hmm.
Then what did my lord, GB did was, my lord, petitioner service from assistant librarian, that was, my lord, upgraded as, my lord, librarian. That your lordship finds at page 46. That is the resolution of the GB. The date is, my lord. No.
Appointment.
2012.
Appointment.
Then-
Appointment.
My lord, upgradation as, my lord, librarian.
What is the appointment?
Page
After the
46.
upgradation?
My lord, the resolution is at, my lord,
Only that.
page 46, my lord.
Only the
No,
resolution.
no, my lord, the page 49, your lordship will get the order.
Yes, 49.
49. Muhammad Rafiqul Islam, M. who was appointed as assistant
28
librarian in
weeks.
the Jammunal College by the resolution number such and such, has GB has decided to upgrade him from assistant librarian to librarian and regularize him in service with effect of his date of joining. This is important, my lord. Date of
As the
joining.
assistant librarian in
17/16.
Jamunamukh College by Jovision, now the GB has decided to upgrade him from assistant to librarian and regular service with effect from date of joining on date. 17/6/2012. Hmm?
My lord.
Yes.
So my lord, his initial date of joining as assistant librarian was my lord 10/12/2010. And this upgradation is 17/6/2012. But then my lord, he has not, his service was continuous and he did not submit any, my lord, any joining report as a librarian because that was a constant, my lord, continuation. And my lord, he continued as the librarian. Now, if your lordship.
So you as a librarian with effect to 2012.
My lord, upgradation is from 2012.
Ah. See, it says as in librarian and regularized service with effect date of his joining on the duty, white so and so. That is 7/06/2012. So you fulfill that 6 years is there.
My lord, requirement is 6 years. My lord, I'll put on that matter.
6 years in service before 2006. It's not.
Now, my lord, for the purpose of.
So you just relate whether as per sections 4 are you eligible?
Yes, my lord, that is what my submission is.
Let us see section 4. 4 again. Section 4.
Now, if your lordship comes to rule 4 again, my lord, your lordship may kindly come to the proviso to subsection 2, proviso Roman 3.
No. Is it?
Page 93. My lord.
Hmm.
The requirement is Roman 3, subsection 2. Must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institutions, which must be on 31/12/2010. Now, my lord, my submission before your lordship is that there is no post of assistant librarian, and he has been continuing to discharge his duties continuously from the date of his initial appointment, and this subsection, this of the proviso, my lord, does not require. It requires, my lord, only continuous service.
But then your regulation is with effect from 2012.
As my lord librarian, but there was no, my lord, so far as the post of assistant librarian is concerned, there is no post, but I will show from the my lord schedule itself. Therefore, his continuation has to be counted from the date of his initial appointment. In the meantime, he has also, my lord, obtained his PhD degree in library science.
And when did you have the educational qualification?
That your lordship will find at my lord page 58.
Ah.
My lord, the HSLC, HSL graduation may not be relevant, my lord. Post graduation in 2011.
Which year? 1/1/2011. It should be 1/1/2011.
Yes, my lord.
As on 1/1/2011.
Post graduation, my lord.
Close to sub-rule 2. Subsection 2. School are recognized in 2006.
My lord, it was my lord provincialized.
No, recognized.
Initial recruitment, my lord.
Recognition. See, it says
From the
employed to be provincial under this act must have been working in the concerned bench education that have been recognized by competent authority on or before 1/1/2006. Roman 1.
My lord.
Second is you must have the minimum education and professional qualification as on 0/01/2011. Then third is 6 years continuous. So your appointment is 20/03/12/2010. When did you obtain the Master in Library Science. There has to be honored before 1/1/2011 or as on 1/1/2011.
My lord, may I draw your lordship's attention, there has been an amendment, my lord, of the act, at page 66
Of
of the writ petition, my lord.
66. Twenty 20, yes.
Page 66, my lord.
Hmm.
Where it is explained to amend the Assam Education Provincial Service Notification Act 2018. Now, my lord, this amendment, this act may be called the Assam Education Provincial Act 2020. It shall be deemed to have come into force on such date as may be appointed by the state government. Then, my lord, 2. In the principal act for the existing schedule in respect of degree college, the following shall be substituted. Now, your lordship will kindly see, there is a post of librarian, there is no post of assistant librarian. So far as the scale is concerned, note, any librarian who has already acquired the qualification required as per UGC norms and guidelines in force on the date of issue of his or appointment order shall be entitled to pay an allowance.
Where you are reading?
My lord, page 66, right hand column, my lord. The notes, my lord.
Any librarian who has
already acquired the qualification required as per UGC norms and guidelines in force on the date of issue of his or appointment order shall be entitled to pay an allowances equivalent to assistant professor from the date of issue of such appointment order, provided that librarian who acquires such qualification within 5 years from the date of issue of his or appointment order shall also be entitled to pay an allowances equivalent to assistant professor with effect from the date of acquiring such qualification as per UGC norms and guidelines for the time being in force. Provided further that the librarian shall be treated as non-vocational academic staff. Now, my lord, I acquired the qualification of Master of Library Science on 26/10/2011.
Is your institution is a college?
It's a college.
Venture college. Okay.
Now provincialized.
Maximum number of posts to be provincialized in each institution.
There is a post where I am rendering my service, but I have been, my lord, deprived of that benefit.
When did you obtain this MA?
Master of
Master Library
Science,
Science?
the date is 26/10/2011.
26.
10/2011.
11. Yes. Where's the schedule in the Principal Act?
My lord, in the
Principal Act, where is the schedule?
That your lordship will find at page 97.
97.
Current pagination, but it is last part of 2018 Act.
The schedule, man.
In the schedule, librarian was missing. As such, this
So
amendment.
by this amendment, librarian has been inserted, added.
So because of that amendment, my lord, I cannot be deprived of the provincialization. That is my case, my lord.
See, under this act, is it, the schools are provincialized for all time to come? Is that it?
Till my lord.
Any school can be provincialized, or the employees or the teaching staff known as can be provincialized all time to come.
On fulfillment of the conditions, yes, my lord, but then the government as a policy matter, my lord, it has decided that there may not be any.
No, I'm just asking, I'm just curious to know
My lord.
whether any schools under this act has to be provincialized
No, only.
for all time to come,
My
or
lord.
it is a kind of the existing and recognized school.
In fact, my lord, although.
Okay, as per this state, a school has to be recognized in 2006. Okay. After that, they are not entitled to be provincialized. Schools,
Some.
I mean, schools and college institutions.
Residential schools may have been, my lord, left out. Those perhaps the authorities may consider, but then government, my lord, as I understand.
But as per clause, I mean, subsection 2,
Yes,
clause 1, it has to be recognized before
yes.
2006.
So
Okay.
if any college, any institution is left out, my lord, maybe government may consider, but otherwise, my lord, there will not be any further provincialization, as I understand, my.
Is the extent of the government, they will not consider any fresh institution for further provincialization.
That cannot be, because subsection 2(1) says it has to be recognized before
2006.
2000, by 2006. Yes.
This is my case, my lord.
My lord, from the college, on behalf of the college of, principal of the college, my lord.
You have filed affidavit.
My lord, only, my lord,
No, have you filed the affidavit?
No.
Yes, you make your submission.
No, otherwise, my lord, I'll just make my lordship only one thing, that 4 dates, your lordship, crucial, that maybe, I think few your lordship has pointed. Bachelor of Library Science on 12/9/2010.
Bachelor of
Library Science. 12/9/2010.
12/9.
2010.
2010.
Master of Library Science 26/10/2011.
Yes.
And then, my lord, your lordship's in the appointment. Appointment is, my lord, joining is 10/12/2010. As assistant librarian.
12. Joining is 10, 12. 10, 12.
2010. And upgradation to librarian on 28/6/2012.
28? 28?
6.
6.
2012.
Yes.
So, my lord, as your lordship has gone through the section 4 of the act, my lord. Section 4, your lordship has already gone. Over there, my lord, I just a small submission that it is must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution. Not the post, but institution. He must have joined the institution. Because, my lord, why I'm saying this, during the provincialization process, lots of teachers who were given the promotion to the headmaster, principal, or all these things, those who are not, it was considered the duration, the time spent in the school, my lord. And in any case, what my lord has posed a question regarding the qualification, that will take care of this proviso to the amendment, my lord. If your lordship has seen this amendment, that page 66, would your lordship be pleased to go again one minute?
Yes, what does it say? Where is the proviso? There is no proviso. Hmm?
Page 66.
Hmm.
Page 66.
Ah.
My lord,
Hmm.
the second pair I provided. My lord got it.
No, is regarding qualification required as per norms and guidelines for some data issued. It's a pay allowance only. With regard to pay allowances.
Provided that librarian who
Requested
acquires such
qualification
qualification
with
within
date of
5
issue of
years from the date of issue of his/her appointment order shall also be entitled to pay and allowances.
It is in respect of the pay and allowances only.
Now, another thing who
With
acquires,
equivalent with the assistant professor.
I'm saying,
It doesn't talk about the provincialization.
showing there is a rider of completion of the qualification within 5 years, the first 3 lines.
In respect of pay and allowances, equivalent with the assistant professor.
Yes.
That's all. It has no relevancy. So far as the provincialization is concerned. It's clearly said on top, fixed monthly salary, so fixed monthly salary, so and so.
My lord, it has a slight hint towards the provincialization, my lord.
No.
Then I leave it to your lordship.
I beg to differ. This is only for the purpose of pay and allowances. It would equivalent with the assistant professor.
My lord, I've got that much, and I think my submission is
This
that
may be relevant for the purpose of the post which has been included in the schedule. Because earlier there is no librarian.
Yes.
That's all. Otherwise, you are supporting that he or she, he is entitled to be provincial. His service is entitled to be provisionalized. Yes. You filed affidavit. Saying what?
Kept saying that, Lordship, this petition is not maintainable here as because alternative statutory remedies there, Lordship. First of all, Lordship, section 8 is there, Lordship.
Section?
Section 8.
Just wait.
Page 95, Lordship.
You are for standing council. Higher education. Hmm. Yes. Not maintainable. Alternative remedy. Under section 8 of 2018. Let us see one by one, section 8. The state level scrutiny committee shall be the appellate authority in respect of any recommendation of district committee and the state government in concerned administrative department. And the state and the concerned administrative shall be the appellate authority in respect. Has the case of the petitioner been recommended? Then
It was not recommended.
you read the section 8.
Not
Shall be the appellate in respect of any recommendation of district and the state so and so shall be recommendation. In respect of recommendation of state level is recommendation. There is no recommendation, not considered at all. So he's for this thing.
District level committee considered. Then, Lordship, if it is not recommended to Lordship, then his case cannot be considered, Lordship.
Huh?
The committee is not recommended, Lordship.
Why?
State committee is not recommended,
So
Lordship.
therefore, you have to consider, the state committee has to consider,
Where is the recommended district committee, Lordship? There is no document
district
here.
committee has to recommend.
There is not a single document here, Lordship. Single document here, Lordship.
Therefore,
Lord.
that is why he's before us.
Otherwise, I'll place.
His case has not been recommended, it has not been considered at all. Had it been rejected or recommended, or if he agreed by that recommendation of some other person, omitting him or ignoring him, then appeal may lie.
Our affidavit.
Because it has to be,
Affidavit, our affidavit, my lord, may kindly place our affidavit. Lord.
yes, that-
Paragraph, if, that be the solo, I am in respect of section 8, I have skipped, Lordship. Paragraph 6 onwards, Lordship.
Paragraph
Page-
five,
page
you have-
73, Lordship.
you have paragraph 5, 6, 7. Provincial and must have minimum education provision laid down on the so and so and must be rendered at least 6 years from the so and joining in the so and the.
In paragraph 6,
Limited
Lordship,
by
that the
limits
deponent
and
begs to state that, may I read, Lordship?
So your ground is that, I mean, your stand is as per section 421. 4
1, 2, and Lordship, 1, 3, Lordship.
422 and 3. He has not rendered 6 years, right? Or obtained the education qualification. Or as on 01/01/2011. Then 6 years, no, he has not rendered 6 years. And the certificates of MSc and all, mastered in library science, obtained from some private university, for which you have made a correspondence, but then there's no reply. And if he had pursued the university, I mean, this thing, he has no continuous service also. That is your state.
And Lordship, we suppose that that certificate also genuine one, Lordship. Then also he has not completed the, Lordship, the stipulated period prescribed by the state, Lordship.
For librarian, you need to have a master degree, not be
Not
bachelor.
Not bachelor, master's, Lordship. So, Lordship, statutory provision again, my lord may kindly peruse, Lordship. After that, I will go to the petition, Lordship. However, I am relying paragraph 6, 7, 8, Lordship.
Yes, I have seen it.
And 11.
Yes.
And Lordship, regarding that part, already Lordship has indicated it is only for the purpose of pay, Lordship.
Yes.
Paragraph
But that
11.
has been included. The post has been included in the college. It has been earlier, there's no, as per the schedule, there's no librarian. It was only assistant librarian. These are two, I mean, what they have read, what I previously found is in respect of pay and allowances with the equivalent with the assistant professor. It has no relevant prima facie, but so far as the insertion of post of librarian in the institute in the schedule, that means the librarian is required.
So, Lordship, again,
The post is there.
page 66, my lord, may kindly peruse. Page 66, Lordship. Page 66. It's a amendment of 2018, Lordship.
Yes, we have seen it.
Lordship.
any librarian who has already acquired their qualification.
It's okay, I've seen it.
Yes, because Lordship, it is an amendment of 2018 Lordship. After that, so many persons were appointed Lordship. And if they have acquired the qualification Lordship, they are entitled to the pay equivalent to the assistant professor Lordship. This is the reason. And otherwise Lordship, the persons who were appointed as a librarian Lordship, who have completed the educational qualification within a prescribed period of Lordship 5 years period, then they are Lordship, Lordship the equivalent pay to the assistant professor.
Yes.
As because Lordship, librarian masters as well as net slate is required Lordship. That's why here indicated that Lordship, UGC required qualification Lordship. And for example, my lord may kindly peruse page 68. Page 68 Lordship, there is a appointment order was tutor librarian Lordship. Tutor librarian is because Lordship, she has the masters, but Lordship, she has not the required qualification. That's why she was appointed tutor librarian Lordship.
Page 60. This is by, this is what?
Yes, Lordship, just for example, I shown the one annexer annexed
Issuance
by the
of the government sanction orders on the services of following employees, so has been provisional and she is an employee of this thing with effect from this with the service have been.
It said Lordship, the persons who have not the qualified criteria Lordship, that's why she was appointed tutor librarian, and that my lord may kindly peruse 8 column Lordship, 8 column my lord may kindly peruse. Date of joining Lordship, 7/11/2009 Lordship.
Ha.
7/11/2009. And she was Lordship joined as a librarian on 7/11/2009, and her service was Lordship provincialized on 2021 as a tutor librarian Lordship. Yeah, Lordship. The petitioner was joined as a librarian Lordship on 2012 Lordship. And he has not completed the required qualification benchmark which was given in the particular post Lordship. So that's why he was not regularized, not provincialized Lordship. As an assistant librarian also, he has only Lordship 1 year or 2 year Lordship. So Lordship, paragraph 8, our affidavit. Paragraph 8 Lordship, did not join and serve as a librarian on or before 31/12/2010 Lordship. Here the required qualification is that Lordship must have rendered at least 6 years continuous service, so and so from the date of joining in the concerned venture education institution, which must be on 31/12/2010 Lordship. Before 31/12/2010 Lordship, that particular persons never appointed as a librarian Lordship. And he was on 2012 Lordship, and he has not completed the Lordship 6 years period Lordship, which was prescribed by the statute Lordship. Regarding that part, joining letter, my lord may kindly peruse Lordship, joining letter. Page 32 of the repetition Lordship.
Page 32.
32 of the repetition Lordship, he has joined as a Lordship, assistant librarian Lordship. Appointed as an assistant librarian.
Then why he has not been appointed the provincial as an assistant librarian?
He has not completed the assistant librarian post for 6 years Lordship. If
he joins, if he joined in 2010, by 2007, 6 years. 17. That's why I'm saying, why not provincial as an assistant librarian?
From 2012 onwards, he not in that particular post Lordship. If that particular person is not in the particular post Lordship, how that persons can be Lordship regularized in that particular?
So in this case, according to 2012, even if he has joined as a librarian, he has not completed 5 years, 6 years, but as on 01/01/2017.
And as an assistant librarian, he has only Lordship 2 years period Lordship.
Okay.
Only 2 years period. Or Lordship,
They said that it has been upgraded.
How Lordship can be upgraded Lordship? He can
No,
be upgraded.
resolution has shows that they upgraded.
Upgraded from where Lordship?
Assistant librarian.
From which period Lordship he was upgraded? He was upgraded from 2012 Lordship.
Huh.
2012 as a librarian.
So once it is upgraded, the post which was earlier serving, that has also be counted.
There is no provisions for upgradation Lordship.
But you are not saying that after upgradation he is not serving as librarian.
Yes, sir. Serving the- Yes,
You have
sir.
said that librarian, as a librarian is serving since 2012. You are saying.
Serving at-
Huh. So once it is the post is upgraded, that will be counted for the purpose of the qualifying years.
That part cannot. Particular post, he should be there Lordship.
So once, that's what I'm saying. If he is promoted, one has to have the,
How can they?
no, how, see, I'm just wait for it. That's why. Once the post is upgraded, for the purpose of counting of the length of service in a particular post. So this, you cannot ignore the earlier period of service which he has served.
It is in respect.
Bef-
That part of the service jurisprudence is a correct principle of law, is in respect of persons. Where one post is there, there is a provisions for upgradation Lordship. Then he will carry forward that past
But you
service.
are admitting that they are serving, he's serving as a librarian.
See, it is there, serving as a librarian or serving as assistant librarian is a totally different post Lordship. There is no provisions for
Therefore-
upgradation Lordship.
Therefore, once the requirement is serving in the institution, then it has to be counted.
That serving in the institution in which post Lordship?
You will have to read along with that upgradation.
Upgradation cannot be lost. There is no provisions for upgradation. Librarian is a direct recruitment post Lordship. It is not an upgraded post Lordship. Direct librarian, assistant professor, all other Lordship, direct recruitment post. It's not a get 4, get 3 post Lordship.
Must have rendered at least 6 years continuous service from the date of joining in this concerned venture education institution.
Librarian Lordship is a direct recruitment post, so I have just seen, just. I don't make-
Sir, except for reputing in the an affidavit, did you consider his case?
This case was never placed before us. Lordship. It's a
That's why.
better-
That's why.
better details to Lordship.
That's
So I
why.
am saying that
That's why you consider. We're not asking. I will not direct you to provincialize his service. You consider whether he is entitled or not, because he has not been considered at all.
But a procedure prescribed by the state of Lordship.
Huh.
We have no objection. It's sent to the district level committee, then comes to the state. I have no objection. I have no objection. Otherwise,
Any district level, any committee is a party here.
not the party yet. When their case was not that particular case. Yeah, my lord may kindly pay Lordship. It is not his case Lordship that his case was never considered, never placed before the statutory authority Lordship. It's not their case Lordship. If we go by the Lordship, Omar Khan judgment Lordship, then the pair cannot be Lordship, mold out Lordship. Provincialized pair number 1 Lordship, respondent to consider case of the provincialization of his service who has been serving as so and so, so and so, so and so, as a librarian of the so and so, so and so, so and so Lordship. His case is not placed to the Lordship, statutory committee Lordship.
Consider the case of the petitioner. Reasonable payer.
I
You
have
may,
no
you may,
objection.
you may reject it also.
I have no objection.
Will
Lordship
not
may-
say that you provincialize his service. As per the act, strictly as per the act, you consider.
Strictly as per the act, first district level committee, then state level committee, I have no objection Lordship.
Consider. Anyway, that is my privacy view. Let us see.
I know.
That's all. Anybody would like to rely on his judgment? No.
That's what I will not-
Judgment is not required.
If Lordship, if that Lordship is just not considered at all Lordship, then I will not rely any judgment.
Yes.
I will not rely any judgment Lordship.
No, he's not been considered at all.
Lordship.
Is
As
not it?
per the documents, nothing is there Lordship.
Not considered.
As
Therefore,
per the documents, it is.
therefore, we may direct you to, not only you, I mean the respondents, whoever, strictly as per the provisions of the Act of 2018, we may direct you to consider. Consider.
See, as per the act. On good will.
Yes, we'll see section 2, 3, 4. Read with amendment to the schedule.
Amendment is in respect of the existing employee.
Yes.
Amendment is not. Amendment is lordship what up.
No, that has been included in there because that schedule has been amended. Nah? That schedule 2 has been amended by inserting the post of librarian.
Section 7 district level committee and state level committee. That part my lord may indicate.
8, I'm not convinced. I'll record your submission, but I have noted it down.
That his case was never placed before any authority. 8 is not required. Lord. 7 will come.
So should I record that also?
Not required. 7 will come.
Maintainability will not record.
The case proceed, it's not placed before any other authority. That portion is not.
So you abandon it.
If his case was not placed, Lordship, why I should Lordship argue that?
Yes, so I'll not record it.
Lordship. Section 7, my lord.
Because unnecessary will be troubling the paper and pen, paper and ink for one paragraph on the maintainability, only for rejection.
Everything was. The
So
environmental
will not record
degradation
that.
was.
Will not record the maintainability.
His view is that his case was never
Yes.
placed before any other authority.
I think it's never been considered.
Then environmental degradation, I not required.
Well, I'll only 2-3 sentences, my lord. One aspect, my lord, my learned friend has a problem with the upgradation order. In the event, my lord, the upgradation order is not there, my lord, then I fulfill 7 years continuous service because, my lord, earlier assistant librarian post was there, subsequently librarian post has been.
But
created.
there is your after the upgradation, your post has been regularized. You have been regularized with effect on 2012.
Yes, my lord.
So everything, the first service, it goes.
What am I am submitting, my lord?
It's just a step.
Because my learned friend's submission is that there is no provision for upgradation. So, my lord, if your lordship holds that the upgradation.
No, we'll not go into it. But problem is, as per the provision, you need to render 6 years.
My lord.
If you counted it from 2012,
Then, my
you
lord,
don't
not
complete
fulfill.
6 years.
But then the per service, as your lordship has already observed, my lord, the per service.
That it's a gray area. I would like I'll look into it, but I'm not sure. And if you are not eligible under the rules, I mean under the provision of the Act, it will be futile to direct them to consider. All right. So this
One more submission, my lord.
you may make a submission on this. Suppose the post you are appointed in this case, assistant librarian, that has been upgraded, right? But from a particular date. After the upgradation, your post you have been appointed and regularized from a particular date. That is in this case 2012. For the purpose of counting the length of service, whether the first service in the lower post can be counted.
No.
It's a gray area.
Yes, true, my lord. But then, my lord, what I submit is that, my lord, if the upgradation is not permissible, then, my lord, if your lordship holds that, my lord, leaves aside the, my lord.
No, we'll not go into that. Though he has submitted, we'll not consider all this thing. That whether the upgradation is permissible, we'll not go into this. No, we'll not go into all this thing. See, this is for provincialization. Once it is provincialized, the employees become the government servant. Until the time you don't have anything to say. The governing body, on their own wisdom, or maybe whatever power, they have upgraded it. Until the time it's provincialized, you provincialize the service. You have no authority to poke a nose on the power of the governing body. You see, that's what I'm saying. You see.
Lordship has already made up the mind that his case was.
No, I have not made up. I'll examine.
Lordship has
I have heard you only.
Lordship has
Just
already-
now I have heard you.
Lordship has already indicated that his case was never placed before any other authority for consideration. That part section 7 may be followed. That is my submission.
Okay.
My lord, if he has completed only one sentence, my lord, you are quite considering that your lordship will kindly, my lord, come to the Roman 3 proviso, which requires continuous service. That is one aspect. And secondly, my lord, whether his case was-
Continuous service means in a particular post.
only, my lord, I am pointing out your lordship will.
No,
consider-
your submission, according to me, continuous service which has to read with a particular post, not all the posts.
My lord, that provision, my lord, does not say says, my lord, only continuous service. That is one aspect your lord
Okay.
consider. The other is that, my learned friend has submitted that his case was never placed before the, my lord, the state level or district level committees. These are not there in the pleading. I have taken a ground, my lord, the affidavit in opposition is not para-wise. And now the submission has been made that it has not been placed. My lord, I have.
I am not submitting. I just indicate that, Lordship, as per the documents, there is no records for submission. This is not my.
No,
submission.
whether your case has been considered or is it?
No, my lord, because the only order by which I was aggrieved that, my lord, the provincialization of the other employees of the college and my name was not there. So what happened, transpired within them, my lord, that I do not know. That I do not know.
What is that, the order of provincialization?
Your
Where
lord,
is
you will
that?
find at page 63. 61 is the, my lord,
60?
provincial teaching staff. And for non-teaching staff, my lord, page 63. My name does not figure. That is why I am before your lordship. Whether they have considered it has been placed before the district level
Yes.
or.
In that case, I think he may be right. If you are challenging this, what is that, my note?
Page 63, my lord.
This is what?
That is the order of provincialization of the non-teaching staff.
Library assistant is there. Vishnu Das. It's Jamuna Mukh College,
Jamuna,
page 63.
my lord. This is the, my lord, the following, the employees of Jamuna College have been provincialized.
Huh.
And my name is not there, that's why I am before your lordship. I am not aware, my lord, what the.
Then, Lordship, section 8 will come. Then section 8 will come, Lordship. If he has challenged that particular order, then section 8 will come.
This is of 2021, right? This order is 2021.
Yeah, my lord, 5th February 2021, man.
But there's the serial number for Vishnu Das, assistant, library assistant.
Is another.
Lordship, library assistant,
That is a great tip.
library assistant and assistant library to defined post, Lordship. Library assistant. is a
Senior
grade-
assistant, senior library assistant. Earlier, initially you were library assistant.
Assistant library.
assistant library.
Library assistant is something different.
Peon.
Okay. So there's no post, there's no,
Yes.
There is no appointment in respect of a sub-librarian
or librarian.
Yes, because, Lordship, none has found the qualification criteria prescribed by the state. That is the reason, Lordship. If they have challenged that particular order, Lordship, it's come under section 8, Lordship.
Yes.
Come under section 8. এই পিছনে কোন আপনি পিছনে কে বকি আছে?
Yes, sir. He may be correct. If you are challenging this, that by this order you have not been.
Your lordship will kindly see the prayer, my lord. My prayer is only consideration. I do not challenge it. They are provincialized, my lord, fine.
Okay.
Whether my case has been considered or not, that also, my lord, is not reflected either in my this order or in the affidavit.
So record doesn't indicate that whether your case has not been considered or not.
That has not been indicated.
Your lordship permission, my lord, I just. I will miss one of the.
Who are you?
policy, my lord.
Huh?
They have appointed me, I have rendered service, my lord, I am fully, that human aspect is there, my lord.
One,
Page 28 marks.
your prompting is enough. It's okay. Page? Huh, what does it say? Yes, read it.
Unanimously decided to select the petitioner.
28.
Which
Huh.
for the petitioner.
Hmm. Yes.
Mention that since the post of librarian is lying vacant and such if so and so.
Obtains a required academic.
Then it can be upgraded to the post of librarian.
Okay. So it's not a upgradation of post. The person has been upgraded.
Yes.
Why you are so fond of him?
I have rendered service, my lord. They have
No,
appointed-
I'm on lighter note. Don't take it seriously. You need a librarian.
Not only him, Lordship.
Ah.
Librarian required, then we can also buy equipment. Now it's a provincialized college, Lordship. It's no difficulty, Lordship. They have sent a proposal to us, Lordship. If they require the librarian post, Lordship.
There is no
We can do that better by through advertisement, Lordship. If not qualified, Lordship.
Don't reveal now. Don't reveal your secret now.
Lordship.
Future secret where you can resort it to, don't reveal it.
Obliged.
Don't make them more wiser. Okay.
I'm highly
And
obliged, my lord.
Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. M. Sharma, Learned Counsel for the petitioner, and also had. You are one.
Yeah, I'm for one and
Who are one?
1 and 3.
K. Gogol, Learned Standing Counsel, Higher Education Department. Correspondent 1 in 3. Who is for 2?
finance, Lordship. B name may be recorded, right?
B. Gogoi.
He's in court.
B. Gogoi.
B Gogoi.
B. Gogoi, your cousin.
Yeah, we have cousin
Cousin.
brothers. Lordship.
Cousin brother.
From my mother's.
And J. Abedin, correspondent number 4. I'll not make it CAB. It makes you lazy. I'll pass the order. It may take 2-3 days. Let us see. I'll not make it CAB. I'll pass the order.
Last item is.
Obliged.
We'll come back at 2 o'clock.
Matters pertaining to Itanagar bench. Orders item 1, election petition 7 of 2024, 1 and 2.
Of my esteemed colleague, Mr. Ruturaj. Since I'm not feeling well, I have COVID-like symptoms and there are some urinary issues also. So, my lord, I'll complete my part first. And thereafter, my lord, he can very well give a reply. And I will be relieved in that case early. Since there was no other way out, I had to come.
Yes.
Because basically, my lord, the issues pertain to two first information reports.
Yes.
Pertain to, my lord, two first information reports that were shown to PW1 on the last occasion. By way of an IA, argument has been advanced that those two FIR at this stage cannot be exhibited as an evidence number 1.
Number two, they can't be, because they're trying to project the case that it is not their exhibits. I think basically, these are the issues. Now, my lord, the FIRs, two FIRs which were shown to PW1 were the registered certified copies of the FIR. Now, certified copies of the FIR are public documents. If any authority is needed for this principle, there is a judgment of Division Bench of Delhi High Court authored by Justice Deepak Mishra, as his lordship then was, wherein lots of authorities have been cited of the High Court and the Supreme Court. So, my lord, I will just refer to that very particular judgment, then I will show your lordship certain relevant provisions of law. The relevant paragraphs in this judgment, my lord, are para 11, 12, 13, 14, and 16. My lord may kindly, sorry, I have not written those paragraphs. Para 11, 12, 13, 14, and 16. Lordship may kindly see para 11. First, we shall refer to section, whether my lord has got it. First, we shall refer to section 74 of the Evidence Act. That is old Evidence Act, but terry materia, my lord, with a different number. In the new regulation, the same provision is there. Public documents. The following documents are public documents. One, documents forming the acts or records of the acts. One, of the sovereign authority. Two, of official bodies and tribunals. And three, of public officers, legislative, judicial, and executive, of any part of India or of the Commonwealth or of a foreign country. Two, public records kept in any state or private documents. Section 76 of the Evidence Act being pertinent is reproduced below. Certified copies of public documents. Every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees. Therefore, together with the certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be, and such certificate shall be dated and subscribed by such officers with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of a seal, and such copies so certified shall be called certified copies. Explanation: any officer who by the ordinary course of official duty is authorized to deliver such copies shall be deemed to have the custody of such documents within the meaning of this section. A division bench of Allahabad High Court in such and such has ruled that the first information report is a public document. In such and such, it has been held thus, quote, the FIR being a record of the acts of the public officers prepared in discharge of the official duty is such a public document as defined under section 74 of the Evidence Act. Under section 76 of the Evidence Act, every public officer having the custody of a public document which any person has a right to inspect is bound to give such person on demand a copy of it on payment of the legal fees therefore. In this context, we may refer with profit to the decision in such and such, wherein a division bench of Madhya Pradesh High Court has opined that a first information report is not a privileged document under the Evidence Act. Thus, there can be no trace of doubt that FIR is a public document as defined under section 74 of the Evidence Act. Then, my lord, reference is made to, my lord, will find in para 16, the lower portion, the sub-para in such and such, Jayanti Bhai, Lalu Bhai Patel versus State of Gujarat, such and such, the High Court of Gujarat has ruled thus. Lord, the quotation is there. So, my lord, this settles the law that certified copy of the FIR is a public document. Now, my lord, with this, I will refer to my lord certain provisions under the Bharatiya Saksha Adhiniyam. Just, my lord, for the benefit of a lordship, the earlier section 74 of the old Evidence Act is also, my lord, section 74, subsection 1 of the new regulation. Whether my lord has been given the copy of the Adhiniyam, sorry.
Section?
Yes. Now, my lord will find in the comparative table itself, because in every Adhiniyam copy, for the benefit, they have given the comparative table wherein the old section and its corresponding, the new provision under the Adhiniyam has been shown side by side. So my lord will find section 74 of the Indian Evidence Act, old act, is also section 74 of the Adhiniyam. Section 74 subsection 1. Then my lord, section 76 of the old Evidence Act, that is certified copies of public document, that is section 75 of the Adhiniyam, certified copies of public document, section 75. Then my lord, section 76 of the Adhiniyam may be seen, proof of documents by production of certified copies, section 76. Section 76. Such certified copies may be produced in proof of the contents of the public documents or part of the public documents of which they purport to be copies. Then my lord will find section 78 of the Adhiniyam. Presumption as to genuineness of certified copies. There is a presumption itself that it is a genuine document. The court shall presume to be genuine every document purporting to be a certificate or certified copy or other document which is by law declared to be admissible as evidence of any particular fact and which purports to be duly certified by any officer of central government or of a state government, provided that such document is substantially in the form and purports to be executed in the manner directed by law in that behalf. So, my lord, along with the authority, the relevant provisions make it very clear that certified copy of the FIR is admissible in evidence, and my lord, it's a public document, and my lord will presume the genuineness of this document and no further proof is required. Even then, my lord, the Supreme Court, there are, in fact, observation of Justice Gajendra Gatkar, which are quoted with approval by other high courts. I refer to 1963 SEC Online, Supreme Court 36. That is Justice Gajendra Gatkar and Madamachi Ramappa. I'll give the copy. The court took it as a settled law that no witness is required to prove it. It's a certified copy, nothing more is needed. So, my lord will see paragraph 9. The 9th line, possibly, my lord, from the top. It has been fairly conceded by such and such for the respondent before us that this was plainly erroneous in law. The document in question being a certified copy of a public document need not have been proved by calling a witness.
Paragraph?
Para 9, my lord, 9th line from the beginning. Beginning of para 9, 9th line. It has been fairly conceded. The court took it as a settled law. Once the council concedes, fair enough, that's the law. It has been fairly conceded. My lord has got it.
Yes.
Because by instances for the respondent before us that this was plainly erroneous in law. The document in question being a certified copy of a public document need not have been proved by calling a witness. Here, my lord, High Court said no witness has not been called. We would not take it to be proved. The court said that this was erroneous. Now, my lord, even this factum was, my lord, High Court accepted as a principle. The Madamachi principle was reiterated by the High Court of Bombay in Tukaram S. Dighole versus Manikrao Shivaji. Yes. I'll give this to
paragraph 70, Madhamachi principle is reiterated by the Bombay High Court.
Paragraph
7.
7.
Para 17, my lord.
Yes.
In Madhamachi Ramappa, the Supreme Court has observed that a document which is a certified copy of a public document need not be proved by calling a witness. The submission such and such. So
Para
let's say,
para 17.
yes, paragraph 17.
17.
17. Madhamachi principle, Bombay High Court accepted as a correct principle of law. Now, my lord, I will turn to the very judgment of Delhi High Court, relied on by my esteemed colleague on the last occasion. The judgment itself favors us. I'll now refer to this very judgment of justice and law. My lord, para 5 would throw light on the facts. The petitioner defendant, because this was a case, my lord, wherein the High Court was dealing with a private document. But even then, certain interesting principles were explained. The petitioner defendant, during the cross-examination of the respondent plaintiff, put to him a handwritten document purporting to be a draft of the application for withdrawal of objections. It is inter alia the case of the petitioner defendant that the said document is in the handwriting of the respondent plaintiff, and the withdrawal of objections was to be in terms of the said document. The respondent plaintiff, however, when confronted with the said document, denied the same to be in his handwriting and also denied the same to be the draft of the application for withdrawal to be filed, and also denied any knowledge thereof. So, my lord, it was in cross-examination, it was said, look, this is your handwriting, your document. He denied his handwriting. He did not accept it. Now, my lord, it is in this very context, in paragraph 8, lordship may kindly turn to para 8. Order 7, rule 14.4 and order 8, 1A and rule sub-rule 4, as well as order 13, rule 1, sub-rule 3 provide that the provisions requiring parties to file documents along with their pleadings and or before the settlement of issues do not apply to documents produced for the cross-examination. I'm sorry, possibly. I think Justice Endlaw's judgment, which was given by my esteemed colleague on the last occasion.
It's not here. Anyway, we did it.
Extra copy nahi hai.
Give my copy.
I think they have left there somewhere. It on our bench. Yes. I think they should.
Then, my lord, I come to the law after para 5 is the factual part, wherein, my lord, in cross, it was the handwritten, it was a document in the handwriting of the petitioner, which was shown to him. He denied it is his handwriting. He denied the document itself. That was the context. And then the court refers to, my lord, in paragraph 8, order 7, rule 14.4, order 8, rule 1A4, as well as rule 13, sub rule 1.3, and then says, referring to this provision, the court explains the principle that the provisions requiring parties to file documents along with their pleadings and or before the settlement of issues do not apply to documents produced for the cross-examination of the witnesses of the other party. To the same effect, section 145 of the Evidence Act also permits document to be put to the witnesses, though it doesn't provide whether such documents should be already on the court record or can be produced shown for the first time. Now it's important. However, in view of the unambiguous provisions of the CPC, it cannot be held that the document cannot be produced or shown for the first time during cross-examination. Because the law that document should be filed, should be part of the record is not applicable when it comes to cross-examination via the clear mandate of CPC. If the witness to whom the said document is put identifies his handwriting, stroke signature, or any writing, stroke signatures of any other person on the said document or otherwise admits the said documents, the same poses no problem, and correctly so. Because then the document stands admitted into evidence. However, the question arises as to what is the course to be followed
if the witness denies the said document, is the document to be kept on the court file or to be returned to the party producing the same? So this was a query the court raised in the present case. My lord, I would humbly submit, pausing here, that in our case, the question even doesn't arise, because if it is the certified copy of the FIR, which is a public document and by itself is admissible, and its genuineness has to be treated to be proved, then, my lord, as to what the witness feels or believes is absolutely irrelevant. It's inconsequential. He can't deny the certified copy of the FIR. Next paragraph. This question also, in my view, is also not difficult to answer. It cannot possibly said that the document should be returned to the party. If the document is so returned, it will not be possible for the court to, at a subsequent stage, consider as to what was the document put and what was denied by the witness. In a given case, it is possible that the answer of the witness on being confronted with the document may not be unambiguous. This is vital, my lord. In a given case, it is possible that the answer of the witness on being confronted with the document may not be unambiguous. It may still be open to the court to consider whether on the basis of the said answer of the witness, the document stands admitted or proved or not, and or what is the effect to be given to the said answer. It is not, my lord, in the case of a public document, which is a certified copy. The court says if it is a private document, even that could be treated to have been proved subject to the answer. If in the answer, the witness admits the said document, it would be treated to be proved. It depends upon the nature of answer. Here, my lord, I will show the answer also in respect of an FIR. The next question which arises is that if the document is so placed on the court file, whether it becomes the copy. Okay, my lord has well copy has come.
It's okay, you read it.
Paragraph 10.
Please read it.
The next
Please
question.
continue.
The next question which arises is that if the document is so placed on the court file, whether it becomes so treated as a document of the party producing the same, and is that party entitled to prove the said document, notwithstanding having not filed the same earlier as required by law, or the use of the said document is to be confined only to confront the witness to whom it was put and cannot be permitted to be proved by that party with evidence. This was the question, my lord, which on the last occasion was raised by my esteemed colleague. It was contended that, look, the document which we had shown during cross-examination, that document, whether it belongs to them or it belongs to us, our case was it belongs to us. It has to be shown as our exhibit. They were submitting to the contrary, and that is why they were objecting to it. Then comes para 11, the legislative intent behind Order 7, Rule 14, Sub-Rule 4, and Order 8, Rule 4(1)(a), Sub-Rule 4, and Order 13, Rule 1, Sub-Rule 3, appears to permit an element of surprise, which is very important in the cross-examination of witnesses. A litigant may well be of the opinion that if the document on the basis whereof he seeks to demolish the case of the adversary is filed on the court record along with pleadings or before framing of issues with the resultant knowledge to the adversary may come prepared with his applies thereto. On the contrary, if permitted to show stroke produce the document owing to element of surprise, the adversary or witness may blurt out the truth. Once it is held that the litigant is entitled to such right, in my view, it would be too harsh to make the same subject to the condition that the litigant would thereafter be deprived of the right to prove the said document himself. Thus, if the witnesses to whom the document is put in cross-examination fails to admit the document, the party so putting the document in its own evidence would be entitled to prove the same. If it is a private document, in the event document is denied, I am entitled to prove the same in my evidence. But my lord, here I would submit, this being a public document, certified copy of a public document, genuineness of which is presumed as per the mandate of law. Nothing more was required at this stage. It could have been exhibited straight away. However, the same should not be understood as laying down that such party for the said reason and to prove the said document would be entitled to lead evidence which otherwise it is not entitled to as per a scheme of CPC and evidence law. For instance, if the document is shown by the defendant to the plaintiff's witness and the plaintiff's witness denies the same, the defendant can prove the document in his own evidence. Then, my lord, in paragraph 12, court gives its opinion. I may, however, put a line of caution over here. It is often found that a party which has otherwise failed to file documents at the appropriate stage attempts to smuggle in the documents and the evidence of the witness of the adversary by putting the documents to the witness, whether relevant to that witness or not. The court should be cautious in this regard. Only those documents with which the witness is concerned and are expected to know or answer ought to be permitted to be put to the witness in the cross-examination. Then, my lord, I come to paragraph 15. The court refers to the case laws. I answer the question framed above accordingly. This petition succeeds and is allowed. The petitioner stroke defendant was entitled to put the document in cross-examination of the respondent plaintiff, notwithstanding the denial by the respondent plaintiff. The petitioner defendant is entitled to otherwise prove the said document. This is, my lord, so far as private document is concerned. Now, my lord, lordship may kindly see the answer given by the PW1 in his cross-examination so far as the first FIR is concerned. What did he say in respect of the first FIR? My lord, this was in the cross-examination. The first day, my lord, of the cross-examination, the second page, second para. At this stage, I was shown a copy of the FIR dated 19/4/2024, lodged by presiding officer of Longtail polling station, Bengia Raja. The FIR names two accused persons, namely Tadar Akap and Tadar Kachi. Tadar Akap is my biological younger brother and Tadar Kachi is my cousin. Then, my lord, this was marked by us, we made it RW1. Then, my lord, on further question, he says, though I do not recall the name of the person who lodged an FIR in respect of Tadar Takam, that is the second FIR, my lord, second FIR. But it is likely, second FIR meaning thereby, my lord, accusing us of wrongdoing when the FIR was lost. In answer to that, he says, I do not know. I do not recall the name of the person who lodged an FIR in respect of Tadar Takam, but it is likely that the informant was one of my party workers or agents. Then comes, with regard to the second case involving Tadar Takam, I do not have any knowledge as to whether the said case has been decided by the court or not. However, this is important. However, it is true that the case relating to the first incident, that is first FIR, involving Tadar Akap and Tadar Kachi is presently pending trial. So he knows that case which arose from that FIR is pending trial. I would submit this would also amount to, in his cross, admitting the existence of such an FIR. He knew about it because he knows the pendency of the trial also. Of course, my lord, I would concede that so far as second FIR is concerned, wherein there was an accusation pertaining to circulation of a threatening message, etc., he did not admit anything. But I would submit, my lord, both the FIRs being certified copies of public document, nothing more was needed. Lordship had seen those certified copies, they have to be treated to be proved, and they can be marked as our exhibit, RW1 and RW3. Now, my lord, so far as our case is concerned, our case, my lord, we have outlined, so far as the principle is concerned, in our objection in para 3.1 and para 3.2.
my lord, in paragraph 3, we refer to the legal provisions. Then, my lord, in para 3.1, we have enunciated the proposition like this. I read from here, my lord, from my objection, para 3.1. In the case of private documents, regardless of the fact that the document in question, in the case of private documents, regardless of the fact that the document in question is a photocopy of the original copy, it is open for the plaintiff or plaintiff's witnesses to deny the same or question the veracity of the same. However, there is also a possibility that the answer of the witness on being confronted with the document may be such that the court may form an opinion that the document stands proved and can be marked as exhibit of the defendant. If the answer of the plaintiff or of the plaintiff's witnesses on being confronted with such document is such that the court is of the opinion that the document doesn't stand proved, then in such a case, the defendant would be required to prove such a document, after which it would be marked as exhibit of the defendant. That is, my lord, in regard to private document. Now, para 3.2, I deal with, my lord, public document. In the case of public document, if the copy is shown to the plaintiff or plaintiff's witnesses during cross-examination is a photocopy of the original, and the plaintiff or plaintiff's witness does not admit the said document or give an answer in respect of the said document which is ambiguous, then in such a situation, the defendant would be required to prove such public document, after which it would be marked as exhibit of the defendant. However, the situation becomes totally different when certified copy of a public document or its original copy is shown to the plaintiff or plaintiff's witnesses during cross-examination. In such a case, regardless of refusal of the plaintiff or plaintiff's witnesses to admit the said document, it has to be treated as proved and marked as exhibit of the defendant. This is because certified copy of a public document is presumed to be genuine and is admissible as evidence as per the scheme of Bharatiya Sakshya Adhiniyam 2023. So, my lord, this is the principle, my lord, we have placed for my lord's consideration, and I humbly submit that since in respect of both the aforementioned FIR, we had produced the certified copies of the FIR, which is presumed to be genuine, and may not that are part of the record now, they have been rightly exhibited to be our documents and marked as RW1 and RW3. That's my submission, my lord. And I would only, my lord, whatever, my lord, I don't think I have any more reply to give or anything to say. My lord will forgive me. And my esteemed colleague agreed that date commencing from 25th of May, my lord. My lord, since my lord will be there in Itanagar during that time, if the matter is fixed, hopefully I'll be okay and I'll be able to complete, my lord, my cross-examination. Oblige, my lord, my London friend would be here, my lord.
Yes. Health is more important.
They will be here.
Health is everything.
That's all. If, my lord, any clarification is needed, my lord, he will note down, and my lord, in written note, I will send to your lordship.
Lordship, may I have my application, my lord? Para 3 of my application.
Yes.
My lord, my senior colleague has read out the deposition, my lord, the cross-examination, where the witness says that he left that place of the polling booth at around 2 o'clock, and this incident happened after that. So he was not present when this incident happened. According to him, it was the returning candidate's person who has broken the EVM machine. With this information also he received from the SP over telephone. So he is not in witness to whatever has happened, whatever has been recorded in the FIR, my lord. So he is not present there. So, my lord, the purpose of confronting a witness in the cross-examination is to discredit his depositions, my lord. When he is not even present, he has not witnessed what has happened. So therefore, putting an FIR and exhibiting that FIR through him is not a correct procedure, my lord.
Because he admittedly says, my lord, first half I was there, second half I was not there, and this incident happened in the second half. So he is not in witness to this incident. So 145 of the Evidence Act, my lord, now it is 148. So it says, my lord, he can be confronted with something which he is aware of, my lord. If he is not aware of, he cannot be confronted with that. He has no knowledge of that. 145 and 146, my lord. So, and the public document, my lord, the argument that has been made, section 77, that says that the contents of public document will be stand proof. There is no problem with that, because it says the contents of the FIR as written in the FIR. So the figures in the FIR, the narration of facts in the FIR, that this FIR contains this facts, that is proved by the certified copy. Whether that is correct or not, that is a matter of evidence. That is not proved by production of certified copy. Just for example, my lord, a sale deed, a certified copy of sale deed is exhibited in a suit. The execution of the sale deed is proved. The narration of fact inside the sale deed, like possession has been handed over, like payment has been made, those facts are not proved. Those has to be proved separately. Likewise, my lord, in a FIR, when it is my witness is confronted, my lord, he is saying I am not there. I don't know. I was not even present there. So there is no point in confronting that witness with that fact and try to impeach him, impeach or discredit his credibility. So therefore, my lord, this cannot be exhibited through this witness, because both the FIRs, my lord, he has stated he has no knowledge of the contents or the incident as a whole. He only says that there is a case pending that I know, but as far as the contents of the FIR, he has no knowledge. So therefore, my lord, when he doesn't, he pleads ignorance of the facts of the contents, he cannot be confronted with that fact, and that cannot be exhibited through them. They may exhibit it later on, subject to permission of the court, because they have to take leave of the court to produce fresh documents, but that is a separate issue. But through this witness, they cannot exhibit it. Lordship may kindly have the CPC, my lord. Order 7, Rule 14, my lord. Order 7, Rule 14, Sub-Rule 4, my lord. So, my lord, it says, my lord, that normally all documents has to accompany the plaint. When a plaint is filed in a suit, everything has to accompany there. If some document is not available to the plaintiff, he has to state under whose possession these documents are. That is Sub-Rule 3. 2, Sub-Rule 2. And Sub-Rule 3 says that if
come to
Sub-Rule 2, Sub-Rule 3 says, my lord, if there is any document he wants to produce later on, he has to seek leave of the court, which we have sought in this case, my lord. Your lordship will recall in the earlier round of litigation, my lord, IAs we have filed. Your lordship has granted me. Sub-Rule 4 is the relevant provision, my lord. Nothing, this is the exception, my lord. Nothing in this rule shall apply to document produced for the cross-examination of the plaintiff's witness or handed over to the witness merely to refresh his memory. So here, my lord, it is in two parts. The first is cross-examination of the plaintiff's witness. That is the first part. Second part is handed over to the witness merely to refresh his memory. The first part is, my lord, confronting the witness. So this is basically the first part is during cross-examination. The second part, handed over to the witness merely to refresh his memory, is during the examination in chief or re-examination. So, my lord, the first part relates directly to section 145 and 146 of the Evidence Act. Lordship, may I kindly have now 145 of the Evidence Act. It is now, my lord, 148 in the new act, my lord.
Something new. Adenium.
So these are similar perimeter provision, my lord. In order 7, it is for plaintiff. Order 8, it is for the defendant. And then order 13, it is for both the parties. So identical provisions. I'm referring to in the Evidence Act, my lord, the new act 148. Bharatiya Sakshaya Adhiniyam, 2023. Lordship has that 148? Yes, my lord. So this is examination as to the previous statement in writing. So, my lord, 148, a witness may be cross-examined as to the previous statement made by him in writing or reduced into writing and relevant to matters in question without such writing being shown to him. So this is the first part, my lord. It says any document, my lord, may be shown to the witness which he has written, his own handwriting. That can be shown to him during cross-examination, not any other documents. So therefore, my lord, the father or being without such writing being shown to him or being proved. But if it is intended to contradict him by the writing, his attention must therefore, before the writing can be proved, be called to those parts of it which are to be used for the purpose of contradicting. So, my lord, this is exactly this provision which is used by my learned friend to contradict the witness. He is producing a document to contradict challenge the veracity of the witness. Now the FIR is not written by him. Because under 148, my lord, a witness must be cross-examined as to the previous statement made by him in writing or reduced in writing. So it has to be his statement or his writing. Without such writing being shown to him. So normally, my lord, I will just try to explain this, my lord, because when the IO, my lord, appears in any proceedings, in any trial, he may be asked general questions, my lord. So whether this witness had stated this to you before. So he may give an answer. Yes, this statement, witness has stated this. Then, my lord, he is confronted with the 161 statement saying you have not written down that in that statement. So this is a contradiction. You are trying to improve. So this is 148 exactly that contradiction and trying to discredit the witness by showing that he is improving his case. So in our case, my lord, the witness is confronted with a document not only it is not written by him. He says I was not even present. I don't know anything about that incident. So therefore, my lord, it cannot be exhibited through him. Because the limited purpose of confronting a witness is 148. Nothing more than that, my lord. As far as, my lord, the public document concept is concerned, my lord, that is section 77. Now it is, my lord, in the new act. 77.
You read the entire 148.
Yes, my lord.
You read the entire 148.
148, yes, my lord.
A witness may be cross-examined.
Yes, my lord. A witness.
By him writing or reduced into writing.
May I read, my lord? A witness may be cross-examined as to previous statements made by him in writing or reduced into writing and relevant to matters in question. It has to be relevant to the matter in question, matter in issue. It cannot be something irrelevant, comma, without such writing being shown to him or being proved. So, my lord, without showing that, he can be asked a general question, just like the IO can be asked a question whether this witness had made such and such statement to you or not. The IO answers. And then he can be confronted, my lord, with the statements which he has recorded in 161. I read further, my lord, but if it is intended to contradict him by the writing, his statement must, before the writing can be proved, be called to those parts of which are to be used for the purpose of contradicting him. So whether the contradiction, the IO has to be, his attention has to be drawn to that part of the statement from the records to which we say you are improving your statement. So this is, the general principle of contradicting or impeaching a witness during cross-examination by the other side. In any case, in this case, the document which has been shown is neither written by the witness nor reduced in writing. It is somebody else's document, informant is someone else, not the witness. So therefore, he cannot be confronted with that. Secondly, the 77, the public document, because public document, should I read this 148 again, any 77, then we come back to that 77, that public document, because the public document by itself, there are two stages,
Are you saying that this FIR cannot be, since he has not written the FIR, cannot be exhibited?
I have judgment, says that in a criminal proceedings, Supreme Court and High Court has held that an FIR can be, a witness can be confronted with an FIR only when he is an informant. Then only he can be confronted. Nobody else, even a injured witness was not allowed to be confronted with the contents of an FIR. Because the limit of FIR is very narrow, It is only to initiate the proceedings, the criminal.
That is another context.
Yes,
Within a particular.
So therefore, only issue here is, since he is not the author of it, he is not aware of it.
So he has not been exhibited through him as his documents.
Yes. He has, he
has exhibited as a public documents only.
Public document also, he cannot do it because he, the purpose of exhibiting and then marking a document through a witness, because once the document is shown to a witness, he is basically confronted with the contents of the documents. If he says I doesn't know, I was not there. So therefore the contents of the document also he cannot vouch for it. He cannot prove anything because he has no knowledge. So therefore that document, since he has no knowledge of the incident of the document, that cannot be exhibited through him.
Once we got it exhibited, what can we do now?
It has to be, because that's why we moved that application, because it has to be, because they have in their evidence, they can produce witnesses to exhibit this document. It can be marked. It can be kept in the record as a marked document. Not an exhibit, because the moment we make it exhibit, it will prove that he is vouching for the contents of the document also. The contents of the document, as for him, is correct. But he has stated on oath that he is not present at that point in time. Even if it is a public document, then also, because section 77 only says, the contents of the public documents as it is exists, that is a proof of that. Certified copy is of proof of that. Whether the contents are true or not, that is a matter of evidence. That he is saying, I am not even there. How can I say it is correct, not correct? So he cannot be confronted with that. This is one judgment, where
necessary.
Correct.
Nothing more. It's no relevancy so far as this court is concerned. Case is concerned.
Para 4, one line I'm just showing, Para 4, the 5th line from the top, PW3 cannot be discredited for the statement made in the FIR, as an FIR can be utilized only for the purpose of corroborating or contradicting the maker thereof. PW1 admittedly was not an eyewitness to the of the occurrence. So PW1 was the informant, my lord, in this case. They tried to contradict PW3 with an FIR. Court did not permit that to happen, my lord, since he is not the author of the FIR. In our case, my lord, the witness is neither informant, he was not even present. PW3, PW1 in this case were at least present, were witnesses to the occurrence.
See, when the documents the witness cannot be contradict unless the documents is, if he's not the maker of that document.
Yes, yes. He is not. He is not. If he is not a maker of the document, my lord, if he is not named in the document, there has to be some connection with the document. If he is an accused, he can be, my lord.
That's his previous record.
Ha. So strictly, if we go by 148, my lord, which I have just read, my lord, it says it has to be in his writing.
We'll see. That's all.
My lord, I have in my application, my lord, I have
See, whole day we cannot.
No, just
Very
few,
small matter we
just
cannot-
few paragraphs. I have that will suffice, my lord, because that is the argument I am making, my lord, in the application. So para 4, my lord. So it says, my lord, it will appear that PW1 has neither identified nor admitted the contents of the exhibit. 5, my lords, I have stated he has not vouched for the genuineness of the said documents nor admitted the truth or correctness of any of the allegations or recitals. He has stated, my lord, he has no personal knowledge of the contents of the RW1 and RW3. He was not present at the time of the alleged incident recorded therein, nor he was the informant, witness, or accused in the said cases, my lord. Para 6, my lord, I have narrated the facts of the principles of this case, my lord. It cannot be. Para 7 and then para 9, my lord. This is also important, my lord. This takes care of the public document concept, my lord. That it is further submitted that mere fact that RW1 and RW3 are certified copies of the public documents does not in any manner cure the infirmity, aforesaid infirmity. The provisions relating to certified copy of public document only obviate the need to prove the execution and registration of such document. They do not dispense with the requirement of proving the truth of the contents thereof. So, my lord, the public document, my lord, is only the execution, the registration in this case, registration of FIR and the contents of the FIR. That the entire FIR contains these allegations. That stands proved by public document, by certified copy of a public document. But whether the contents are correct or not, that cannot be proved, my lord. And therefore, that cannot be put to the witness for discrediting his, because he was not even there. Even, my lord, in that Justice Anlo judgment, my lord, the Delhi High Court judgment, which we have cited, my lord.
Yes.
Para 11 of that judgment, my lord, it says, my lord, it cannot be done in a wholesale, a very limited document can be produced to confront the witness, my lord. It cannot be a bulk document. Para 11 of that document, my lord, of the judgment, my lord, page 309, last para, my lord. Last 3 lines, my lord. May I read, my lord? Thus, if the witness to whom the document is put in cross-examination fails to admit the
Since you
document.
have filed the application,
Yes.
can this not be taken up at the time of argument?
Yes, my lord, it can be. I was suggesting this only, my lord, because this will again, lordship will pass an order which will ultimately, my lord, impact the final. It should be ideally it should be done at the end, my lord, because otherwise these issues will crop up again and again.
So since you have already filed the affidavit, I mean the IA,
This should be
can be
kept
considered at the
at
time of
yes, my
argument
lord,
only.
yes, that can be
Because
done.
once you have exhibited, it's difficult to de-exhibit again.
That only lordship may record ki this is an objection which a file, the objection has been filed as a IA, that will be considered at the time of hearing, final hearing. That can be done, my lord. That is what we wanted.
You inform, I think
That's better.
if I decide it this way, that will have a bearing
Impact,
again.
Yes.
So since as an objection you have already filed,
Filed
that
it,
it could not have been exhibited. But
Yes.
once you have exhibited, that will be considered at the
The
time
time of
final argument.
Yes, yes.
Is not it?
Yes, yes. Lordship may record student's order that IA has been filed and the IA will be decided at the time of along with the final hearing.
So we'll take it up tomorrow again. You inform your senior.
Okay.
Tomorrow, he's not keeping well, my lord. That's the problem.
You just discuss with him. We'll list it tomorrow. We're not passing any long order. We'll say that as regards the exhibits of 1 and 2, 1 and 3, this IA has been filed, which will be considered at the time of
Yes, that's
hearing, final
absolutely.
hearing.
That is a better way of doing it.
Because if I consider it now,
Yes.
suppose if it's allowed or if we reject it, will have a bearing in the further proceedings.
Lordship will have to discuss the merit of the case to
Yes.
decide this.
Yes.
It is which is
We have to see everything. Is that it?
Yes, my lord.
We'll fix the matter tomorrow. You just discuss. We didn't have an instruction. This is my view of this court. You just discuss with your senior.
Yes, yes. We'll come back, my lord, tomorrow. Otherwise, my lord,
Heard Mr. So-and-so, so-and-so. And PKT, yeah. IUM. List the matter again tomorrow. We'll for that
Yes,
only
yes.
we'll just. If he agrees, if he doesn't agree, also I'll decide.
yes, my lord. Even in some of the exhibits, our exhibit, my lord, your lordship has recorded.
You
their
have
objection.
understood.
My lord.
The court's view is that this application, this object, it's basically an objection.
Yes.
Will be considered at the time of final hearing.
Yes, yes.
Because it has already been brought on record. That order will be passed tomorrow.
I shall
Discuss with him. If he agrees, well and good.
He can allows me a moment. I can even call on telephone also right now.
Right now, yes, you
A
can.
moment's time.
Because same thing has happened in our exhibits also. Lordship has recorded their objection and kept it pending. The same procedure can be followed.
In this, Mr. T will not easily agree. He would need time. He will take time to think about it.
But there is a precedent in this case only. In his objection that has been followed below. So same principle should follow.
Give me a Lalikumar. Last item.
Lordship, here I am an assistant professor of the mathematics department of the Borderland Territorial Council, Lordship. Further, if Lordship may go to page number 28 and 30, Lordship, that is annexure number 4, Lordship. I was granted medical leave, Lordship.
Yes, but then ultimately what they have said, this what that policy or what it does,
Yes, yes,
notification
Lordship.
of the state government is not applicable to Borderland University. What do you say on that? Otherwise, there is no dispute.
It is absolutely.
Your entitlement is not dispute.
Yes, Lordship.
But then unless there is a provision.
There is a provision, Lordship. If we go to the.
It is by the state government.
Yes, Lordship.
They say now that the state government will not, this will not apply to Bodoland University.
Lordship, I would like to first take you to few.
What is that impugn orders?
Uh,
The communication?
That is the communication is annexure 21, Lordship, page number 77. Lordship.
Sorry, huh?
Annexure 21, page number 77.
Hmm. Twenty?
77, Lordship, page number 77. Annexure 21. Lordship, here, subject with regards to the medical reimbursement bill vouchers in respect of Kunja Priya Kumar Singh, PhD, HOD Mathematical Sciences, Borland University, Kokrajhar. Subject with reference to the subject cited above, I would like to forward here with the medical reimbursement bill vouchers amounting to rupees 19,04,004 rupees only in respect
Service
of.
rule of training and non-teaching is university and the state government are not same. The Assam medical attendance rules is not applicable to the teaching and non-teaching is there. Yes.
Yes, Lordship. Now.
Whether it is applies or not. Do you have a
It
rules?
applies.
Huh?
It applies, Lordship. Let me take you to, Lordship, some important pages first. First, Lordship, if we go to annexure 1617, Lordship, annexure 17, page number 57, Lordship.
May I please your Lordship, my lord? As before, my lord, in this case, what happened, my lord? He has already, my lord, argued the introductory part, my lord. Lordship currently come to the annexure 7, page 57.
You are entitled under which rule?
Yes, my lord. I am coming, my lord.
Come to that.
Yes, my lord. After the
No, Executive Council, there is no dispute. You are
Yes, no,
entitled for 19 lakh something
Yes, my lord.
as per the resolution of the Executive Council, right?
Yes, my lord.
The issue is, and that has been submitted to the department,
Yes, my lord.
right?
Yes, my lord.
Now,
I am coming, my lord.
what they are saying that this rule under which you are claiming.
I am claiming the rule, my lord. If your lordship go through all the document, then your lordship, I can clear all these
It's
things.
not required.
Yes, my lord. I am coming one point, my lord.
Page 77. They are saying that this is not applicable.
Yes, my lord. Actually, rule is applicable. Everything I shall.
You just show.
Yes,
You
that
just
is-
showed
that is-
how this is applicable.
That is why I try to, by level basement, my lord. Lordship, kindly come to that, my lord. Before that, we have to go through the act, Borland University Act, my lord, and everything, my lord. Yeah, your lordship, kindly come to the, my lord, page 1, 2. This act came into force. Your lordship, page 16, my lord. Sorry, my lord, para 16. Sorry, 16, point number, power and duties of the court. Have you lordship got it? Third page. Page 434, my lord.
Act.
Yes, my lord, act. Subject to the provision of this code, the court shall have the following power and duty, namely to review from time to time web policies program of the university suggest measure for the improvement, development of such policies program work and the affair, to consider the annual budget report, annual statement of the account, of the audit report and budget of the university next financial year.
What is this power? What court is this?
Your lordship, 16B.
What is this? Why? Powers and functions of the court. What is this court?
Court means, my lord, that executive council, they have called it court. That executive council of the university, that is called court. That court has been mentioned, my lord. To consider annual report, annual statement account, and the report and the budget of the university for next financial year. 17. The executive council shall be the chief executive body university shall consist the following person, namely Vice Chancellor, Rector, Director of Higher Education, Director of Technical Education, Director of Medical Education Assam, National Board of Secondary Education, 2 head of the department, 2 principal, affiliated degree, and 1 principal government degree college, 4 member.
Where is this? Where is this?
Yes, I am coming because 17(1) is important.
See, court means the court constituted under section 15.
Section.
Where is section 15?
Yes, my lord. Okay, that I have already given. I shall go to it, my lord. আমার এটা কপি না এটা কপি দুটা করব লাগছিল ফটোস্ট
No, no, do you have this?
আছে নেকি এটা 15
Your this thing starts from page 26 and then page 34. I just wanted to know.
Binding one. I have already given section. No, I have given the whole. That is not available with me, my lord. You also kindly go to the section 15. They are more than 15. If you also give me, my lord, I shall show your lordship from that document. এটা করব লাগে না
Chancellor, Vice Chancellor, Rector, Register. Yes. Why you have given this?
My
This
lord,
amendment or what?
no, my lord.
Why this?
This one.
Specific paragraph.
A specific paragraph, a section which I am relying. I am given all these things, my lord. I have segregated from that document, my lord. That is why I am. The subject to the provision of the act as following. Yes, my lord. I am 17, my lord. I am reading the 17, my lord. I am here, my lord, in Executive Council, my lord. Who is the member? Vice Chancellor, Rector, Director of Higher Education, Assam. Director of Technical Education, Assam. Director of Medical Education, Assam. They are the member of the, my lord, Executive Council, my lord. Then your lordship come to the next page, my lord. Power and duties of the Executive Council. Have your lordship got it? Next page. Subject to the Act statute, Executive Council have the power following power duties, namely. Got it, my lord?
Yes, yes, yes.
Yes, my lord. Then your lordship kindly go to the all time skip over there. Your lordship direct come to the next page 436 P.
To exercise all other powers of genuine to exercise of which no specific provision had been made in this act.
Of this
Or
statement.
in, yes, then.
Yes, my lord. Then my lord, your lordship come to the next 19th, my lord. That meaning to exercise all the power of the for exercise of which has no specific provision has been made in this act or statute. The power which is not available in the statute, they have said rule or other, that can be exercised by the Executive Council, where Director of Higher Education, Director of Medical Education is the member of that particular, my lord, committee. Academic Council. The Academic Council shall the following member. Your lordship kindly come to all the member 8, 9, 10. Director of Higher Education, Director of Medical Education, and Director of Health Service. They are all the member of the committee. Then your lordship come to the, my lord, Finance Committee.
Yes.
27. Subsection 4. 2 members to be nominated by the state government, one from the finance and other from the education department. Then, my lord, power and duties of the finance committee.
To deal with such other matters.
Yes, sir. To deal with such other matters relating to financial matter of the university as prescribed by the statute and ordinance. Then your lordship come to the 29, next paragraph 1, my lord, university fund. The universities and Bodoland University funds which shall be credited to the all income, fees, contribution, donation, loan, advance from any other airline. The university may also get ordinance made in this behalf. One or more separate special fund from the administrator and the endowment and trust and grant. The state government shall the purpose of this contribute annually university fund and not less than 40 lakhs rupee to meet the recurring charges of the university. That is important, my lord. Then, my lord, 31, account audit, such annual account, 2, my lord, such annual account shall together with copies of audit report thereon be submitted through the Executive Council, Court, State Government, thereupon the State Government may publish the official gazette. 5, the annual budget estimated FR to in section 16B, 15B, my lord, 16B, shall after this be finalized, executed to be circulated to the State Government, Chancellor and all member of the at least 15 days, they are submitted to the court. Then, my lord, sorry, approval of the Executive Assembly statute. Then, your lordship, come to the Ordinance 33, page 444. That is important, my lord. Have you lordship got it? Page 444. Ordinance subject to Provision Act, Executive Council may make ordinance for the purpose of carrying the statute in respect of all matter which act statute required be or may be provided. Your lordship directly skip the 2D. Creation of provident fund, then disjunctive other fund for the benefit of the employee of the university. On the basis of that, my lord, they have, my lord, first, my leave has been considered under Assam medical attendance rule. Subsequently, they have, my lord, allow my medical bill, my lord. I have given Director of Medical Education, give me, my lord, that assent that medical bill can be considered. And it was going to be, my lord, Director of Health, my lord, medical Education, Director of Education has said that this bill can be considered. Then it was go to the, my lord, Commissioner Office, Joint Commissioner has said your fund can be released. Then thereafter, what happened, my lord? Academic Council repeatedly took the decision to give the medical reimbursement bill. Also, my lord, Academic Council never said that we will not pay the bill. They said fund is not available, my lord. I am coming on that, my lord. Then, my lord, on the basis of that, fund should be released. And what happened, my lord? My client committed a mistake, my lord. I say, my lord, he has given pleadant notice. Then ego of the, my lord, Education Department has been hurt. Then they, who has already given, my lord, consent and extend all this, my lord, letter. If you lordship go to one by one letter, he replied back and refused to pay the bill. Then our High Court passed in this case. If your lordship they go to the affidavit in reply file, I have annexed this order. Passed by this honorable court in this case. You release the fund and you make the modalities. But they have never made, my lord, sincere exercise to release the fund. There are 2 orders passed by this honorable court. I am going through that, my lord, first, before started my case, my lord.
What is this? Provident fund for benefit of the teachers, officers and other. It has no relevance. There is no ordinance to follow the rules of medical this thing. Rules.
Yes, I'm coming, my lord. There is
Any ordinance has been passed.
Any decision has been taken by the Executive Council. They have to follow that order, my lord. They cannot back out this document, my lord.
No, see, would you have given this power to make ordinance?
Yes, my lord.
The Executive Council may make ordinance. Like in the last page, you have issued some ordinance.
Yes, my lord.
As
They
regards
provide benefit for the
Provident fund.
till such time detailed regulation frame, the rule followed by the state government in this regard may be followed by the university. That rule should be followed.
It's for Provident fund only.
For other, they have already stated, my lord.
Where is that ordinance like this?
Section 18, my lord. Section 18, subsection 1, P, my lord. To exercise all other powers for exercise, which has no specific reason, has been act in the statute.
Now, what does it say? Under which provision you are claiming?
Under all this provision, decision has been taken by university. I have a legitimate expectation.
No, decision is something different. Decision has to be taken on certain principle, certain rules or act.
Yes, my lord. No, I am submitting here, my lord, that this.
See, for example,
yes,
the section 33 provides the rule,
Yes.
ordinance Power
Yes,
to
madam.
issue ordinance,
Yes, madam.
make ordinance.
Yes, madam.
Likewise, for Provident Fund, you have issued an order that Assam rules may be followed.
Yes, madam.
Likewise, there must be some decision that this
That
rules-
your lordship allow me to go one by one.
this Assam medical attendance rules under which this reimbursement can be claimed. So you have to have issued an, no, not you, the university has to issue an ordinance
Yes, madam.
or make an ordinance.
Yes, my lord. If they are not doing, it is their, my lord, fault. What happened in the case, your lordship, allow me go through one by one document?
No, it's okay. What is under which provision you are claiming?
I am.
Forget about the decision. Decision is something different.
Yes,
This
madam.
decision, executive council or whatever decision
That
is
your lordship may
based
fix.
on certain,
Yes, my lord. I shall go through all this.
based on certain principles, based on certain circular rules,
madam.
act or any provision.
Claiming this Assam medical attendance rule 2008.
They are saying that it's not applicable to Borderland University.
When they said, earlier they not said.
No, by this impure order, let company, it has said.
After.
So you have to show that saying the director saying is not enough. If it is not applicable, you have to show that it is applicable.
Then I will check, do one thing. I shall next day, I argue them.
That's what I'm saying. This is more, that's why we don't have to go into all these facts. Facts are not disputed.
Yes, madam. I shall
Facts,
do all these things.
you have submitted a
Yes,
bill
madam.
of 21 lakhs.
Yes, madam.
They have taken a decision,
Yes, madam.
correspondence after another,
Yes, madam.
entitling you,
Yes, madam.
the calculating your
Yes, madam.
entitlement as around 19 lakhs and odd.
Yes, madam. I'm
Right.
Yes, madam.
Now, ultimately, when the matter was settling between the authorities, this director has sent a letter, the rules under which you are claiming the medical reimbursement is not applied to university. Then it's because they put a break on this.
Yes,
So simply you have to show
Yes, madam.
that this rule applies.
Yes, madam. I shall
Right.
consider-
That's all.
Let's take another then, madam. I shall-
We could have decided.
Madam.
Anyway, this is the only issue. We'll not go into all this way. So
Issue-
this have no
My-
time. Nowadays, we have no time to go into every papers.
Yes, madam. Lordship, I fix another then, madam.
Get the crux
Yes,
and
yes,
decide.
yes,
Is not it?
I have to interpret the statute also, my lord, from law.
No, you have to see. Suppose you don't have a rule. You are claiming under this medical attendance
Yes, madam.
rule.
Yes, madam.
If they say, now they are saying, director is saying it doesn't apply.
Madam.
Either there must be some ordinance under ordinary ordinance making power under section 33, like which you have in the last page.
Yes, madam.
Kind of ordinance has to be issued. Until you make the rules, this rule will be followed.
madam.
Nobody will stop that.
Yes, madam.
Is not it?
Yes, madam. Lordship, may fix-
Yes, sir.
The rule does not apply.
Why? Just because director says so?
No.
But who are you?
Kindly.
Who are you?
Kindly.
Sir, who are you?
I am appearing for Borderland University.
University.
My lord.
Your executive council all along, one after another, approved, asked for a fund. Now just because director has said that it's not apply, and can you say that it's not apply?
My lord, they are not providing, government has not provided.
So what do you say? Why you are saying that it's not apply?
It has to be adopted. It is not yet been adopted.
You adopted, who has stopped you?
Resolution page 78, my lord, kindly. say, my lord.
78, what does it say?
Statute,
One minute.
all is wrong.
Huh?
My lord, item number 6, page 79.
Huh?
Middle, my lord, see. As such, Assam medical attendance rule is not applicable to the teaching and non-teaching staff of Borderland University, as Borderland University is an autonomous body. The government of Assam has
Okay.
released the grants in aids for salary and infrastructure development purpose only, and not for medical reimbursement, etc.
This is not your decision. This is the you have taken down the letter.
Council resolution, my lord.
No,
My lord,
You have just taken note that the DHE has advised the university to discuss the matter in EC. Your decision is start from here, right? In the recent letter, so and
in
so,
this regard, a welfare.
you read it from this thing in the recent letter.
Lordship, 57 years old, Lordship, go, my lord. They have accepted all the proposals.
No, it's okay.
Yeah.
You read it. This is not your decision. In the recent letter, so and so, that is so and so, the are not same. As such, you have copied it from the letter. In this regard, a welfare scheme may be launched for the medical allowance of the employees. The House is requested to approve the proposal to fight against medical hazard employees of this or may think over the matter to consider committee to find a mechanism for medical reimbursement to the employees of Border.
It has to be, my lord, some.
When it
scheme
was
has to
taken?
be made.
When it was taken? 2016. You have not taken, it's still, Borderland University is still active.
They filed affidavit, I have said that no such medical attendance has been adopted.
No, this
and
cannot
no-
be allowed. That cannot be allowed. Just because director says it is not apply.
My lord, it is not because of direct.
And your page 17 and it's not your decision. They've just recorded. And they've decided to constitute a committee, that's all.
My lord, For.
Heard Mr.
For
NNB
application,
for the
for application of
petitioner
medical.
as well as Mr. AKD Learned Council for the Student Council, Borderland University and Mr. That's for name so and so. Student Council, Higher Secondary, Higher Education. Matters pertains to reimbursement of medical bills under what is Assam?
Assam medical attendance rule.
Under Assam Medical Attendant Rules 2008. List of the petitioner is retired.
He is not prepared.
The petitioner is what? Professor?
Professor.
Hmm?
Professor.
Now professor.
Yes, madam, now professor.
Huh?
Professor of that Borderland University.
Associate professor.
Associate professor in mathematics.
Is a associate professor in the Department of Mathematical Science in the Borderland University. Who claims for medical reimbursement bills amounting to rupees 19 lakhs 04004, huh? Page 79, you check it. Hello. Please stop. Next para. The bond of contention is as to whether bond of contention in the issue is as regards the applicability of the medical the Assam Medical Attendance Rules 2008 to the Borderland University. List of next para. Mr. NNB Chaudhary, on confronting whether any ordinance has been made by the authority of the Executive Council under the Act of under the Borderland University Act 2009 as regards the applicability of the Assam Medical Attendance Rule 2008, press for some time to go through the entire matter and to address this court on the issue. Next para. Considering about that this matter will be listed after?
After, my lord. I have to contact with my client, my lord. I have to verify all the documents, my lord.
After 3 weeks?
Yes, ma'am.
4 weeks? 3 weeks?
4 weeks, my lord. From 5 June to 13 June, I am not available.
This matter after 4 weeks. Huh? No, as agreed to by land council parties, let this matter be listed after 4 weeks. Huh? Okay. I see, huh? Yes. Agreed.
Yes, fine.
Okay.
My lord, he agree.
I'll pass the order then in that case.
Yes, Lord.
We'll say that this is an application so and so,
Yes,
objecting to so and so, exhibit of so and so,
right.
right?
Ah.
And can you write? Aye. Heard Mr.
I am U Pathak, my lord. I am for.
Yes, heard Mr. Rituraj Biswas, learned counsel for the applicant of the election petition, huh? And also heard Mr. Piketty, learned senior counsel, assisted by U Pathak, learned counsel for the opposite party respondents. Next para. Decision application.
Under section 87, my lord.
Huh?
87, one of the,
Is it 87 or only 151?
both, my lord.
Why?
It can be under 87, my lord. Lordship last time pointed out this, my lord. It can be under 87 alone also.
Section 151 of the CPC. We'll just say 19, CPC only. Objecting to the exhibit RW1 and RW3. Executed by the respondent during the exhibited by the 2 and 3 during the cross-examination of in the course of the cross-examination of PW1. PW1. This stuff. Upon consideration, this court is of the view that same shall be taken up at the time of final hearing.
Final hearing, yes, my lord.
At the time of final hearing. Taken up at the time of final hearing.
Yeah.
At the time of hearing or at the time of final hearing?
Final hearing, but because after the cross, my lord, the only final hearing will be left, my lord. So
At the time of
final hearing.
final hearing.
And the cross-examination of PW1 to resume, my lord, because that was stopped. So that might resume, my lord, 25th.
The week beginning from.
No, we have fixed other election method from 26.
In that week,
That week, my lord,
no, that is the only prayer my senior has made, my lord. This entire matter be taken up in the week beginning from 25th. Now 25th is a Monday. So from that week onwards, my lord.
26 also we have fixed.
From 27th.
27. From 27.
27,
The
28.
election petition.
27th is Wednesday.
In the election petition, you write so and so, same number. Election, no, you don't have to write applicant. Huh? Election petitioner, Tiwari, respondent. Huh? We'll just say list on 27.
27, then it will continue, my lord, because of
For cross-examination.
Of PW.
Cross-examination for PW1. Huh? Other PWs will take much, may not take
Very
much
short,
time.
my lord, one page, 2-page affidavit, my lord.
Huh.
So should we call them also, my lord, on?
27 is not possible. On other day we'll mention.
So, because.
You keep them ready.
Ready, okay.
Huh?
Okay.
Yours will be taken up from 27.
27.
Others were fixed on 26.
26. Okay. Petitioner was the principal of Provincialized College, my lord.
Yes.
He initially joined his service, my lord, in the year, my lord, 1985 at Shillong, my lord. Shillong College. Subsequently, my lord, after his selection as a
That matter, I am seeking a little accommodation today, my lord. This matter has been looking after by Mr. D. Opomine, my lord. He is suffering from fever, that's why he could not come to court, my lord. Any date, my lord, next week, my lord?
Just wait. Where is the speaking order?
yes, already, my lord, one order was passed, my lord, by this honorable court, page 65. My lord, Justice Kotaswar Singh, my lord, passed this order.
Okay, directed to consider your case.
Yes, yes, my lord.
Then by, where is the speaking order?
Yes, I have challenged that speaking order, but it was applied for, papers were submitted before the authority. They have lost my papers and this speaking order has been passed, my lord. Page 38, 80, my lord, annexure 38.
Without any pay protection and
Yes, my
technical resignation, join the Harbang so and so
Yes.
without pay protection. There's no technical resignation,
Yes.
no technical release, no pay protection. Again, during joining Gwalpara College, he had not also availed the NPS. No pay protection.
All papers they misplacement. Kindly peruse your lordship, page 77. Short page 77. Annexure 35. All were applied for, but they have lost. This
Good.
letter was issued by the Director of Higher Education. Page 77, Annexure 35.
Regarding pension matter in respect
Yes,
of
ma'am.
Kasim and so and so.
With reference to subject, I would like to return here with the proposal along
I
with
would
the
like
part of
to
service.
return here the proposed project along with paper service in original in respect of is along with a copy speaking order so and so so and so. You are requested to reconstruct the service on the basis of the authentic available in the college in respect of principle as the same is not resolved after repeated herself.
Yes, ma'am. Subsequently, principal submitted status report only because all the papers were misplaced by the department, my lord, itself. Papers deposited there, my lord, page, my lord, 53. These annexure 20.
Difficult.
All papers were deposited there before the authority. They have
If there is no technical resignation, nothing.
Well,
The issue is your joining in Gwalpara University, I mean college is
2010
it still
itself, my
seems
lord,
to be fresh.
from the year 2010
Do
itself.
you have anything to say?
No, yes.
How you are appointed?
By selection, APSC selection, I was appointed.
Then it is a fresh election only.
Kindly peruse your lordship, annexure 12.
What does it say?
Page 37.
What does it say?
This was my first application. I am reading with reference to it was first applied for the pay protection, my lord. With reference to subject area, I have the honor to state that I had.
Anyway, heard Mr. So-and-so learned counsel for the petitioner. Mr. S. Das learned counsel.
Higher education.
Studying submits that this matter is being entrusted to Mr. D. Upamania, who learned counsel, higher education, another learned counsel for higher education, who is stated to be indisposed today, therefore fresh for listing of the matter after 2 weeks.
No, that may be.
As per his convenience, my lord.
Mr. So-and-so appears for respondent number 5. And for respondent 5 is present. Consider the submission of learned counsel. Let this matter that the counsel who has been interested in this matter is indisposed, let this matter be listed. The prayer is allowed. Let this please accordingly list this matter after 3 weeks. 2 weeks.
2 weeks, my lord.
After 2
Maybe
weeks.
that 17. By deducting all portions, my lord, he may be allowed 85. He joined in the government service.